Hello, everybody. Hi. Oh my gosh, there's so many comments already. Hi, sweetie. I really am. Yeah, it was a mild asthma attack, but it was enough that it was like a continuous mild asthma attack. Like it didn't get to the extreme point where I had to go to the hospital or something. And I have a nebulizer here, so had it gotten to the point, I'd used the nebulizer here first, and that probably would have alleviated it. But I had used my rescue inhaler more than I'm supposed to. It was just It was, I think just an allergic reaction to the seasonings that my daughter cooked with. And she didn't use anything funky either. It was like garlic and pepper and salt. She made steaks, and but just the intensity, maybe. I don't know. Maybe that's the only thing I can think of. But hi, Emily, honey. But I am back. I am here. Oh, Laura Wharton. Those crazy sounds are good ones. Hey, Brian Boggs. Good to see you, love. Happy to have you here. Hi, this way up. Happy you made it. Good to see you. Oh my gosh, I have the best friends ever. Hi there, Tammy13. How you doing, love? So happy to see you. Welcome. All the way from Belgium. Oh, she meant 5 stars. Y'all are 5-star folks. That's too much. Y'all, she loves that heater. If I turn the heater on, boom, she is right there. I don't know if you can see her. I don't know if you can see her in her little corner right there. Boop. Yeah, she is right by that heater, and that is where she'll remain for a little bit. I had to turn that on. It was getting a little chilly. I love you so much. Hi, Bonnie, honey. Thank you. Thank you. It's one of my favorites. It makes me feel pretty. I love it. Yes, there we go. Oh my gosh. Ooh, that's good to know. My daughter does have, isn't xanthan gum, isn't that used in like Trident? I know it's, what else is it used in? All the stars. You guys get all of the stars. Every one of them. 5 stars, 7 stars, 12 stars. I don't care however many stars there are. They're yours. I know, you just can't please them. Imagine my job. Oh, wow. Coating on the outside of peanuts? I used to eat peanuts religiously. Every single morning, I would have a part of a bag of peanuts that I shared with my squirrels. The outside squirrels, of course, but I fed them peanuts, so they were mine. Um, but yeah, I would have peanuts and an avocado every morning, and that was my breakfast with my squirrels. Because you know something, avocados, that's like a squirrel's favorite food. They love both the meat of the avocado and the pit. Oh my goodness. And they're so much fun to watch when they attack them. They're awesome. I love squirrels. I love squirrels. We do love you, Emily. We very much love you. Yeah, that's a joke going around here. Some crazy streamer did a impression of a monkey or chimpanzee, and now they're all talking about fermented banana juice like she drank it or something. I have no idea what you're talking about. Not a clue. None. But what I do know is when I do my um when I do my I love you and then the three heart and then the hands heart and then the kiss on the cheek from the two emojis together. Um the hands part, yeah, that doesn't show up. I have it on my banner. And look, it's gone. I've gotta improvise. I'm gonna put it right there. Bloop. Yeah, I don't know, but for some reason it's just not in the coding. Not to my knowledge. Now there is actually a tea made of bananas, peels and all, that helps you sleep at night. It makes you very sleepy, and it's really healthy for you. Basically, you cut a banana in half, throw it in a pot of water, and you boil it, and then you drain the water and drink it, and you will fall asleep. There you go. I haven't tried it, but I've heard about it. Yeah, well, that's what I'm saying. That's what I'm saying. Yep. Yeah, don't do it. Don't do it. Don't get me going. I've already embarrassed my child enough for the day. Well, see, and that's also a method. I just can't do that method, unfortunately. So I have a handsome man in a turtle suit tonight. That thick padding, green, it brings out his eyes. Yeah, yep. He's at the end of this docket. It's not a very long one. We'll get to him very soon enough. Oh, come on, computer. Computadora. Oh, don't you start with me. Last night, I don't know if it was StreamYard or my internet or what, but not last night, but the night before. The last stream I did, it like froze. Everybody thought it was their internet. I could have just kept my mouth shut and gotten away with it. But it was my internet, I'm sure. Yeah. I clicked on it to bring it up, and it decided it didn't want to work, but I got it now.
The conditions that I've ordered of your bond and you show up to court when you're supposed to, you'll never have to pay that money. If you fail to appear or you do not follow the conditions of bond that I've ordered, your bond could be forfeited and you could be responsible for, looks like $2,250 total. You understand that?
I understand it now.
So that should be motivation for you to make sure you show up to court so you're not going to be out $2,250.
Of course. And I also had one more question, if you don't mind. Never mind. Never mind, because I do have court on January 2nd, but I was going to see if we could have it that day too.
So I can't change that. I get available dates from the divisions and I have to stick to their calendar. I don't believe that Judge Ellison has court on the 2nd.
Okay, thank you, sir.
Thank you.
Mr. Ciro, Your Honor.
Court calls Miguel Serio, 23M3500. Good afternoon, Mr. Serio.
Good afternoon.
Sir, did you either watch a video advisement of your rights or did you receive a written advisement of those rights?
Anytime, love.
And do you have any questions about the rights that you were advised of?
No, Your Honor.
In this case, sir, you're being charged with possession of a controlled substance, a class 1 drug misdemeanor, and possession of paraphernalia, a drug petty offense. The court does not see any prior DM1 convictions. This would be a mandatory PR bond. Mr. Hillier, your position.
Your Honor, the people don't object to a PR bond. We do agree that it should be. However, we do ask the court enact monitored sobriety and mandatory protection order for the defendant to remain law-abiding, along with authorization of MIPS and monitored sobriety.
Ms. Nickel.
Your Honor, I don't have a record to make.
Thank you. Mr. Serio, bond will be set at $1,250 personal recognizance. Are you familiar with what that means?
Yes, sir. So I can sign myself out?
Correct, but you have to understand that if you don't show up to court, your bond could be forfeited and you could be responsible for that money. So make sure you show up to court. I am going to order standard pretrial supervision. I'm going to authorize the MIPS program, which is a mental health intervention program. That is not a condition of your bond because it is not mandated, but it is available to you. And you can choose to participate in it if you'd like. I'm ordering that you not consume any alcohol, drugs, or recreational marijuana, and your sobriety will be monitored as directed by pretrial supervision. That's going to include random UAs. You shall remain law-abiding. Report to pretrial within 24 hours of your release. You shall not harass, molest, intimidate, retaliate against, or otherwise tamper with any victim of or witness to the case. Your next court date, sir, is going to be on January 4th at 8:30 a.m. in Division 1A. Do you have any questions for me? Thank you.
Thank you.
Mr. Soto Brotel, Your Honor.
Court calls Jose Soto Bortel, 23M2634. Good afternoon, Mr. Soto Bortel.
Good afternoon.
Sir, did you either watch a video advisement of your rights or did you receive a written advisement of those rights?
Yes.
And do you have any questions about the rights that you were advised of?
No.
In this case, sir, you're being charged with violation of a restraining order, a class 1 misdemeanor, and 2 counts of harassment, a class 2 misdemeanor. Is Keaton Folk or Alexis Bergman present, Mr. Hillier?
1 second, Your Honor.
While you're looking into that, Mr. Hillier, I would note for the record that Mr. Soto Bortel was supposed to appear yesterday from El Paso County. He had been transported here prior to appearing before court, and that's why he is appearing today.
Understood, Judge. I'm ready to state my position. We do believe that a cash-only bond is appropriate. The allegations are very concerning, and we do have concerns for the safety of the victims in this case. We do ask that a no contact order be issued along with a mandatory restraining order, and we do believe that mental health may be a concern here. So we do ask that MIPS be authorized. The amount of cash we defer to the court. We do ask monitored sobriety be issued as well.
Ms. Nichols?
Your Honor, I'm asking for a personal recognizance bond. He has 2 daughters. They live with him. They are 2 months old, and one of them is turning 1 in 4 days. He is a freshman at CSU. He's attending for welding. He's a full-time student and also does some welding trade for some of his school-related expenses. He's lived in Colorado for the last 3 years. He lives in Fort Collins. So we are asking for a personal recognizance bond.
Mr. Soto Bortel, the court takes into consideration CPAT Category 3 for prior failures to appear, but most importantly, I take into consideration the information contained in the affidavit, which I believe is a dangerous allegation. There are threats to kill 2 people, both with a weapon and with your bare hands. I do believe that a cash bond is appropriate and bond will be set in the amount of $250 cash only. I am going to
$250 cash for those threats. That's crazy.
order standard pretrial supervision. I will authorize MIPS, which is a mental health intervention program. That is not a mandatory program, so it's not a condition of your bond, but I'm going to make it available to you and you can choose to participate in it if you would like. I'll order that you not consume any alcohol, drugs, or recreational marijuana, and your sobriety will be monitored as directed by pretrial supervision to include random UAs. You shall not harass, molest, intimidate, retaliate against, or otherwise tamper with any victim of or witness to the case. You shall remain law-abiding and report to pretrial within 24 hours of your release. Based on information contained in the affidavit, I'm ordering that you not possess any weapons, firearms, or ammunition. I am ordering a no-contact order naming Keaton Folk and Alexis Bergman as the protected parties. You shall refrain from contacting those individuals either directly or indirectly, and you must avoid any area that they are known to be located. I will order that you keep a distance of at least 50 yards and that a condition of the no contact order is that you not possess or consume any alcohol or controlled substances. Your next court date, sir, is going to be on January 17th at 2:15 p.m. in Division 3D as in David. Now, Mr. Soto Bortel, I don't know what your plans are regarding representation. If you are going to apply for the public defender, you'll receive an application in your release paperwork. I encourage you, especially since you have till the 17th, which is a few weeks away, enough time to fill out that application and submit it to the public defender so that they have enough time to process your request. Do you have any questions for me?
No, sir.
Thank you.
Mr. Warter, Your Honor.
Thank you.
What are they, Emily? They, I don't know, they look like potato chips or something. What are they, you goofy? I am going to peel pomegranates, so my hands are going to turn red.
Court calls Mark Warder, 23M3018. Good afternoon, Mr. Warder.
Hello.
Sir, did you either watch a video advisement of your rights or did you receive a written advisement of those rights?
I did.
And do you have any questions about the rights that you were advised of?
Not.
In this case, sir, you are being charged with child abuse, a Class 1 misdemeanor, and child abuse, a Class 2 misdemeanor. Is a parent or guardian of Noah Masters present in court today? Mr.
I bet you
Hillier,
can tell
what is
him
your
on the phone.
recommendation?
Your Honor, the allegations in this case are very concerning. We do have concerns for the community, but specifically the children in this case. So we do ask that a no contact order with the victims in this case be authorized or and the victims' guardians. We do ask for a mandatory protection order and MIPS be authorized. We do ask the bond be set for cash only due to the seriousness of the allegations. However, we defer that amount to the court.
Ms. Nickel, my understanding is that Mr. Warder had a private attorney who had logged in but had to log off. He messaged in the chat that his recommendation is for a $1,000 personal recognizance bond.
Your Honor, I would like to still make a record. Mr. Warder and I spoke this morning. Private counsel didn't reach out to let us know not to spend the time. And since we don't have further argument, I'll make requests in support of that PR bond request. And we'd be asking for a co-PR in the alternative. His most recent criminal history is 2016. He's lived in Larimer County his whole life. He lives in Fort Collins. He has 50-50 custody of his children. Important to note, the alleged victim is not his child. He does not live with the alleged victim. I have no objection to no contact order with the alleged victim. Would be objecting to no contact with the alleged victim's guardian. I don't see any basis for that as the request. He is employed. He works as a senior project estimator where he works. The company is Mel Brothers, and he's worked for 13 years. Both of his parents live in Colorado, and he has no failures to appear.
Thank you. The court does note a CPAT category 1 with no failures to appear. Although I have concerns about the allegations in the case, I think that they can be appropriately addressed through pretrial supervision conditions and a no contact.
I bet they look perfect on a phone. I'm just on a laptop and I can't see them as clearly on a laptop. But yeah, okay, now that you've said that, I can make them out, but I had to be told. I'm sorry. I do love you, and I love otters. I really do. Like how they hold hands when they're floating on the river. Oh my God, they're so cute. Okay, I'm done.
So, Mr. Warder, the court will set bond at $1,000 personal recognizance. I am going to order standard pretrial supervision. I'm going to authorize the MIPS program, which is a mental health intervention program. Sir, that is not mandatory. It is not a condition of your bond, but it's available to you if you choose to participate. I'll order that you remain law-abiding and that you report to pretrial within 24 hours of your release. You shall not harass, molest, intimidate, retaliate against, or otherwise tamper with any victim of or witness to the case. I am ordering a no contact order with Noah Masters. He does not live in your home, is that correct?
That is correct, Your Honor.
I'll order that you refrain from contacting him either directly or indirectly, and that you must avoid any area that he is known to be located. That means if he comes over to see his mom, you can't be there. I'm ordering that you keep a 50-yard distance restriction between yourself and Noah Masters. The court is not going to impose a no contact order with the child's guardian, as that is Mr. Warder's spouse, and the court doesn't find any probable cause to or any information in the probable cause affidavit that would lead me to order that that the mother be protected as well. Your next court date, Mr. Warder, is going to be on January 4th at 1:30 p.m. in Division 5D as in David. Do you have any questions for me?
I do not.
Thank you.
Thank you.
Mr. Jackson, Your Honor.
Court calls Jeffrey Jackson, 23T2280. Good afternoon, Mr. Jackson. Sir, did you either watch a video advising you of your rights or did you receive a written advisement of those rights?
We received the written advisement.
And do you have any questions about the rights that you were advised of?
No.
In this case, sir, you're being charged with driving under the influence and open container. What is the people's recommendation?
Your Honor, the people agree with the bond commissioner's recommendations of a $1,750 co-PR bond with enhanced pretrial supervision, along with MIPS be authorized, monitored sobriety, no driving without a valid driver's license and insurance, as well as to remain law-abiding, just a mandatory protection order, and to report to probation within 24 hours of his release.
Ms. Nickel?
I'm asking for a personal recognizance bond or a $150 cash bond in the alternative. He's lived in Colorado his entire life, all of that in Larimer County. He owns his home in Fort Collins that he's owned for the last 10 years. I'm sorry, I misspoke before. He's lived in Larimer County for 10 years, but Colorado his whole life. He is self-employed, a property manager. He has family in Colorado. His dad lives in Larimer County, and his mom, brother, and sister live in the Boulder area.
Thank you. Mr. Jackson, the court sees 2 prior driving with alcohol convictions. I also note from the affidavit that you were located passed out in a truck holding an open can of beer and denied that you had been drinking and denied a chemical test. As a potential 3rd driving and alcohol conviction, I do find that you're a danger to the community. Bond will be set in the amount of $250 cash only. I'm going to order enhanced pretrial supervision. I'll order that you, or I'll authorize MIPS, which is a mental health intervention program. That is not mandatory, but it is available to you if you choose to participate. I'll order that you not consume any alcohol, drugs, or recreational marijuana, and your sobriety will be monitored as directed by pretrial supervision. I'm going to order daily BAs and UAs twice a week with ETG authorized. You shall not drive a vehicle without a valid license or insurance. You must remain law-abiding, and you must report to pretrial within 24 hours of your release. Your next court date is going to be on January 11th at 8:30 a.m. in Division 1A. Do you have any questions for me?
Yeah, so I can drive until I have my DMV hearing, right?
Yeah, if your license hasn't been revoked, then you are able to drive unless and until it is revoked, and you must have valid insurance.
Okay,
Thank you.
thank you.
Mr. Lee, Your Honor.
Court calls Justin Lee, 23M1634.
Man, and that was a good one too. Yes. Hey, it's been a few days. It's been a minute since I've done it. Yep. Where are you going? Where do you think you're going? Sorry. I'm sorry. So he's found passed out behind the wheel of his vehicle, holding the beer can that's not his. And their only concern is make sure that you have a valid license and insurance before you drive. What about an interlock device? Mr. Judge, with your $250 bonds for I will unalive you guy, what is going on in Colorado? Like, for real. Come on. I am more worried about that guy having an interlock device than a valid license.
Good afternoon, Mr. Lee.
Good afternoon. How are you?
I'm well, thank you, sir. Did you either watch a video advisement of your rights or did you receive a written advisement of those rights?
I did.
Do you have any questions about the rights that you were advised of?
No, sir.
In this case, sir, you are being charged with possession of a controlled substance, a class 1 drug misdemeanor, driving under the influence, marijuana use or consumption in a car, and driving under revocation. What is the people's recommendation?
Your Honor, we do agree with the bond commissioner's recommendations to be $1,250 cash surety or $125 cash. We do ask that MIPS be authorized along with pretrial supervision and no driving without a valid license and insurance, mandatory protection order for him to remain law-abiding. And I don't know if I said this, monitored sobriety be ordered as well.
Thank you, Ms. Nickel.
Your Honor, I'm asking for a PR bond or a $100 cash bond in the alternative. He's lived in Colorado his whole life. He lives in a house in Berthoud with his father. His other family in Colorado include his mom and his sister. He is employed. He's a manager at Walgreens, where he's worked for the last 3.5 years. In addition, with his free time in our community, he attends a gym where he has a membership and also plays in several local bands or has played in several local bands.
Thank you. Mr. Lee, the court's going to set bond at $100 cash only. I'll order standard pretrial supervision, and I'll order that you not consume any alcohol, drugs, or recreational marijuana. Your sobriety will be monitored as directed by pretrial supervision, and I'm ordering random BAs as well as random UAs with ETG authorized. You shall not harass, molest, intimidate, retaliate against, or otherwise tamper with any victim of or witness to the case. You shall not drive without a valid license or insurance. You must remain law-abiding and report to pretrial within 24 hours of your release. Your next court date is going to be January 10th at 8:30 a.m. in Division 1A. Do you have any questions for me, sir?
Yes, sir. Just one question. With it being UAs or no substances, even though I have a medical marijuana card, would that be something I can go about or?
So the court's not prohibiting you from using medical marijuana. I'm ordering that you not consume any alcohol, controlled substances, or recreational marijuana. I'm not
understood.
you from using medical marijuana. You will need to provide a copy of your medical card to pretrial supervision.
Okay, understood. I appreciate it.
Any other questions?
No, that's it. Thank you.
Thank you.
Mr. Marshall, Your Honor.
The court calls Brandon Marshall, 23M1636. Good afternoon, Mr. Marshall.
How are you?
Here's our guy.
Well, thank you, sir. Did you either watch a video advisement of your rights or did you receive a written advisement of those rights?
I was just given a written advisement a second ago.
And do you have any questions about the rights that you were advised of?
No.
In this case, sir, you're being charged with violation of a restraining order, a Class 1 misdemeanor, telephone obstruction, a Class 1 misdemeanor, third-degree assault, a Class 1 misdemeanor, theft, a petty offense, obstructing a peace officer, a Class 2 misdemeanor, and a domestic violence sentence enhancer. Is Cassandra Larson present on WebEx? Ms. Larson, are you here?
You'll be here.
Mr. Hillier, what is your recommendation?
Your Honor, I do have a victim statement to read.
Please.
The victim, Cassandra Larson, is in favor of a high cash or cash surety bond. The current protection order conditions include a full no contact with a 50-yard restriction, monitored sobriety, no firearms or weapons, and MIPS. She's also requesting that her daughter, Novalee Larson, be added to the protection order, no contact order as well. Novalee is not Brandon's child, the defendant's child. The people this time, we do find the allegations to be highly concerning, not just to the community, but again to the victim as well. We do believe the victim is in potential danger in this case. So
My phone, so I don't tell I got obstruction of the phone when she called you off my phone.
So,
And she wouldn't leave my residence.
Mr. Marshall, right now,
Well, it's
I'm going to advise
gaslighting.
you to talk about that with Matt Landers when he picks up the case, okay?
Right, hey,
Today's
waiting,
not a
it's
good
been
time to
6
talk about
months.
it.
It's been over 6 months and nothing's been said. She called you off on my stolen phone when she wouldn't leave my property, but I'm in jail with a high bond. I'm a good man, I'm a good father, I don't deserve this. And if you want to use that against me, then go for it.
Mr. Hillier.
Your Honor, the CPAP was not completed, and therefore we don't have a score to base that off of. However, based on the allegations, we do ask for a cash-only bond. In the amount, we defer to the court. We do ask that intensive pretrial supervision be authorized or ordered along with.
I'm going to do my pretrial in hand, and I have no problem doing that. I make every appointment.
I'm going to go ahead and mute you. I've muted you, Mr. Marshall, because you're you're speaking over other people. I'll give you an opportunity to talk, but I'm not going to let you talk over others. Go ahead, Mr. Hillier.
Thank you, Your Honor. We do ask that a no contact order with the victim be placed and a firearm or affidavit for the relinquishment of firearms be filed as well. We do ask on the victim's behalf that her daughter be added to the no contact order.
What's the basis for that request?
I apologize, Judge. I was reading over her statement again. We don't believe that there is a basis for that request.
Thank you. Ms. Nickel.
Your Honor, the only bond he would be able to post is a personal recognizance bond. I'm asking for a personal recognizance bond. I'll note that he's currently participating in competency court and has all of the resources and support that competency court provides in that program. I don't have any details on really what he's utilizing at the moment. It does look like in just about a week ago, he was looking into sober living options. I don't have an update on how that is going. He's lived in Colorado his whole life. He lives in Loveland, not with the alleged victim. He does have bed dates for treatment at North Point Treatment and also has some other applications in as well for inpatient treatment. His whole family lives in Colorado, so he has substantial community ties. I'd be asking the court for a personal recognizance bond in this case. His next court date in competency court is quite a ways out. It's on January 30th. So I think it's probably worthwhile to get him into the competency court docket on this case just to get it rolling a little sooner than that. But I would ask that it be on the competency court docket rather than any other trial division.
Do we have any sooner dates in competency court other than January 30th? Yeah, I can't set this directly into competency court, so I'm going to set him sooner in Division L2, and a referral to competency court can be made at that time. Mr. Marshall, the court's going to set your bond at $150 cash only, and that's based on 10 prior failures to appear. There already being 2 protection orders in place. I am going to order enhanced pretrial supervision. I will authorize MIPS, that is the Mental Health Intervention Program. It's not mandatory, so you don't have to do it. Sounds like you're already receiving some services through the competency court. I will order that you not consume any alcohol, drugs, or recreational marijuana, and your sobriety will be monitored as directed by pretrial supervision. I'm ordering random UAs. You shall not harass, molest, intimidate, retaliate against, or otherwise tamper with any victim of or witness to the case. You shall remain law-abiding and report to pretrial within 24 hours of your release. I'll order that you comply with the previously issued no contact orders in cases 23M5324 and 23M701. I'm also ordering that you have no contact, I'm ordering a no contact order in this case, naming Cassandra Larson as the protected party. You shall refrain from contacting her either directly or indirectly, and you must avoid any area that she is known to be located. I'm ordering a distance restriction of 50 yards. It's also a condition of the no contact order that you not possess or consume any alcohol or controlled substances. Based on your uncooperation in booking, I did not receive an affidavit regarding relinquishment of firearms. Because you're being charged with an offense that is alleged to be an act of domestic violence, it is an order of this court that you relinquish any firearms within 24 hours of your release. The deputy is going to hand you a packet of information that tells you exactly how to relinquish firearms and ammunition. That packet will also include some forms that you're going to have to fill out and turn into the court, and I'm ordering that you do that within 7 days of your release. Failure to relinquish firearms and ammunition within 24 hours or failure to return those forms within 7 days could result in additional charges being filed, your bond being revoked, or you being held in contempt of court. Your
Why
next
not
court
both?
date is going to be on January 4th at 1:30 p.m. in Division L2, and that's at the Loveland Courthouse. Ms. Nicola, it sounds like you said Mr. Landers is already representing him, so he will not need to fill out an application.
That's correct.
Do you have any questions for me, Mr. Marshall?
Yeah, where did the other 8 failures to appear come from?
I'm receiving that
Well, that
information
too.
from, I'm receiving that information from the criminal history report run by pretrial supervision.
Well, they should rerun it with the full name Brandon Scott Marshall because there's someone else running around as Brandon Marshall pretending to be me, fucking my life up very adequately.
Well, I'm going to go off the information that I have in front of me. Do you have any other questions?
Yeah, who can I talk to about this identity theft bullshit? Because it's completely ruining my life.
Well, first of all, I'm going to ask you to watch your language. You're in a court of law, so that's
This
unacceptable.
court of law is incompetent then.
Well, incompetence doesn't mean you don't have to be polite. So you can ask your attorney who to talk to about that. I don't know that there's another Brandon Marshall.
No, trust me, I do.
Okay, well, I'm not changing my ruling. Any other
I'm
questions?
just saying you're basing my bond off of some false allegations.
I disagree. Any other questions?
I don't have 10 failure to appears.
Okay, that's it. Case is complete.
Wasn't he a peach? Oh my goodness. And that guess the picture game, that is like the greatest thing that's happened tonight. That's amazing. Where did it go? Where did it go? Where did the comment go? Where did the comment go? Oh, I can't find it now. Yeah, it was on my list of things to talk about. Yes, my daughter loved the roller skates. She opened them up and she was so stankin' excited. Because like I said, she's wanted them for years. And the first thing she did was go to try them on, and she's like, "Oh, they're not laced. I thought they'd come laced." But yeah, no, she's so happy with them. But it's winter time, so she can't try them out yet. But she tried them on and they fit perfectly. You guys are absolutely amazing. Yes, he should have. But instead they slapped him with $150 cash bond. $150. I just can't fathom that. I can't. There's one a couple towns over. I mean, it's not. It's maybe 20 minutes, half hour-ish away. I don't know when it's open, though. But yeah, that's a good idea. Oh, no. It came with laces. They just weren't laced up and ready to go. So she goes to slide her foot in it, and she was just, the moral of the story is she was way too excited. She was so excited that she didn't realize they weren't laced. And then she had to stop and reel herself in and actually lace them up. No, they came with laces. Everything was fine. She was, cart before the horse. Actually, in my daughter's case, it works the opposite way. Oh. Ultrasound photo, that's what you went with. Okay. I was thinking this was the naughty nightstand chat. Quads. Hey, daughter.
Yep.
Can I see one of your skates, please?
Not right now. I'm sorry. I'm about to go shower.
Oh, okay. Not right now, but later. It'll be okay. She's getting ready to jump into the shower, so she was getting her clothes together and stuff, so she'll get them later. Well, there we go. It probably, I guess it looks maybe like the fetus on the picture, maybe, yeah. Have you seen those 3D ultrasounds? Yeah, okay, now I see it. Yep. Mm-hmm. Oh my gosh, this is gonna drive me crazy. I hate when it chops off part of my head. I can see that. Is that a side effect? Oh, you guys are so darn cute. Oh, it came with them. They're on the skates. I don't know anything about like upgrading them or anything. She got skates. That's what I know. And she wanted them very badly. And now she's happy. So we're going to leave it there where she's happy. All of a sudden you hear the Mario Kart music playing and she's just going to go boom right past. Right. Oh, wouldn't that be a lot of work though? Swapping them out like when you go inside and outside? I don't know. It's too much work for me. I would just take them off and put shoes on. He already goes zoom without them. I have to clean my screen real quick because one of the pomegranates, all of a sudden I just saw a stream and I've got a puddle of pomegranate juice on my screen. So kitty zoom. So I'm going to put a clip on and then I'm going to minimize the screen. And then I'm going to try to clean the screen. Oh, I love you. Oh, goody. That's the goal. I always just rented them straight from the rollers rinks. It was when I was a kid, I'd go every Friday. I'd ride the bus. It was like $12. And then you got in and got to roller skate all night. And then, yeah, it came with the skates. And then you rode the bus home. Ah, we got nice rentals, or at least we did when I was 12. They're probably beat up by now because they're probably using the same skates. It's hard to find roller rinks anymore. They're not as populous as they used to be. I really think we need to bring that back. We need to bring fun skating back. We used to have Johnny Danger from Z104. He would always come to the roller skating rink and he would sign dollar bills and stuff like that. I used to have one. It was in a jewelry box in my mom's room for the longest, but God only knows where it ever ended up. But yeah. Yep, he would come and stand in the big booth in the middle, then, talk. You can't say DJing because he wasn't doing the music aspect of it. He was just the MC for the night. Yeah, it was 6. It was 6 at our rink, but the bus was also 6, so it was 12 for the night. The bus you had to pay the bus driver 12, and that included everything, rather than paying the bus 12 and then getting there and paying the place 6 or 6 and 6. Yeah. Ooh, neat. 90s. I'm not that old. I'm really not that old. Oh, wow. That's nifty. She was getting away with way too much. I had to put her down. She's been spicy and sassy lately. And there's something. Don't you get out of here, fuzz. Piece of fuzz from my little hand wipey thingy that I'm gonna use on my screen. Oh, I love you guys so much. Okay, I gotta put my screen is driving me crazy. I gotta put a clip on so that I can minimize the screen so that I can clean the screen. Because it's gonna drive me bonkers. No, it's gonna drive me bananas.
On the record in the matter of the people of the state of Michigan versus Dylan Patrick Christian, file number 23-01953, counsel appearance.
Assistant Public Defender Sarah Donnelly on behalf of the defendant for the purposes of arraignment only while he appears separately from the Lansing Police Department.
Okay, you're Mr. Dylan Patrick Christian?
Yes, Your Honor.
Okay, Mr. Christian, today's the date and the time set for arraignment. I have here a misdemeanor complaint. The allegations are that on or about June 8th, 2023, that you did allegedly contrary to law commit the act in count 1 of domestic violence, and that you did make an assault or assault and battery upon an Autumn Thwing, an individual with whom you had a child in common, or a resident or former resident of your household, or an individual in which you had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. Restitution may be ordered if convicted, as this may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty, sir?
Yes, Your Honor.
Okay. You have the right to be represented by an attorney, and Ms. Donnelly from the Office of the Public Defender is representing you today for the purposes of your arraignment only. However, you have the right to have an attorney with you to represent you at each stage of the criminal prosecution, and you have the right to have an attorney to represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the Public Defender's Office appointed to represent you at the expense of the public. Do you understand that?
Yes, Your Honor.
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will proceed to a jury trial. And you have the right to a jury trial, and you have the right to the presumption of innocence at your trial. That means you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to confront and cross-examine in court any of the witnesses called to testify against you. You have the right to call your own witnesses or present evidence at trial that you believe further a defense to the charge being brought against you. And you have the right to remain silent at trial and not have silence be used to imply or prove that you're guilty. Do you have any questions about those rights at this time?
No, Your Honor.
Okay, you're currently scheduled for a pre-trial conference before Judge Cynthia Ward. That's going to be December 11th, 2023 at 10 o'clock in the morning. You can appear via Zoom or you can appear in person for that proceeding, okay? For the purposes of his arraignment, is he requesting public defense to represent him in this matter?
Yes, Your Honor.
Okay, and the court will enter a plea of not guilty on your behalf. Is the address at Hartford Road accurate for you, sir?
Yes, Your Honor.
Okay, and that's not an address where the alleged victim lives, correct?
No, Your Honor.
Okay. Are you currently employed?
Yes, Your Honor.
Where is that?
University Edge in East Lansing. It's Michigan State University housing.
Are you currently on probation or on parole?
Not that I'm aware of, Your Honor.
Well, if you were on probation or parole, you would probably know it. Okay, no court has sentenced you to oversight?
No, ma'am.
Okay, do you have any other matters pending in any other courts?
No, Your Honor.
Was he picked up for something else?
Your Honor, all I know this about this warrant.
Okay, I just looking at his criminal history and I see it looks like something else may be pending in Eaton County. You can address bond.
Oh, thank you, Your Honor. Mr. Patrick Christian reports that he doesn't have any violent or felony convictions. He is working in the student housing across from Frandor in East Lansing. He's been doing that job for over 2 years. He reports he he does share a child with the complaining witness. It's a 2-year-old son. He's nonverbal, and there is a specialist that's supposed to meet with him on December 4th, and it's supposed to be a meeting at the alleged victim's home. And unfortunately, Mr. Patrick Christian is supposed to be there, but I don't know if there's anything the court can do. Otherwise, we'd just be requesting a personal recognizance bond with a third party to communicate about custody and maintenance of the child.
Okay. I don't see any prior convictions on his criminal history. A personal recognizance bond will be granted. I'll grant bond in the amount of $500 personal recognizance. There is going to be a no contact order in place for the protection of the alleged victim, Autumn Thwing. Any custody or family related matters that are of concern, he needs to seek his assistance through the family court. I'm not going to address any of that at this court. Okay. While out on bond, you're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to have contact directly or indirectly with the victim in this matter, Autumn Thwing. And that means no third-party contact unless you get an order from the family court saying that you could do so for the purposes of your child care, okay?
Your Honor, thank you.
You're not to possess a firearm or any other dangerous weapon. And you need to report to all of your future court dates. Do you have any questions about your bond conditions?
I do have a question, Your Honor. I own a pistol and a rifle at home. What would I be doing with said items?
You're gonna need to make arrangements because you're not to be in possession of a firearm during the pendency of this matter, okay?
Okay, so as long as it's a friend that can hold it for the time being, is that all right, Your Honor?
That's completely fine. You can make other arrangements. You can have a family member take it that can lawfully take it, but you can't be in possession during the pendency of the matter, okay?
Yes, Your Honor.
Okay. Any other questions?
No, Your Honor.
You're all set for today. Okay, we're on the record in the matter of the people of the state of Michigan versus Sarah Marie Chappelle. Counsel appearance.
Assistant Public Defender Sarah Donnelly on behalf of the defendant for the purpose of arraignment only, while she appears separately from the Lansing Police Department.
Oh, and you're Miss Sarah Marie Chappelle? Can you say that again, because I didn't hear you?
Yes, Your Honor.
Thank you. Today's the date and the time that's set for an arraignment. I have a misdemeanor complaint here. It alleges.
I'm sorry, I had to pause it because I have to tell Catherine Gaston. That's the year I was born. I love you.
That on or about November 23rd, 2023 at the area of 3605 Palmer, which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of assault or assault and battery. It said that you did allegedly make an assault or assault and battery upon the following person, that being a David Anderson, and that this was done contrary to Michigan Compiled Law 750.811. Restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty?
Yes, Your Honor.
Okay, you have the right to counsel, and you have the right to be represented by counsel at each of your court proceedings. Ms. Donnelly is representing you today for the purposes of your arraignment, but you have the right to have court-appointed counsel appointed to represent you if you can't afford to hire an attorney, and you seek to have one appointed. Do you understand your right to counsel?
Yes, Your Honor.
Okay. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You have the right to plead not guilty, or you have the right to stand mute. If you stand mute, the matter will continue all the way to a jury trial. And you have the right to a jury trial. And at the time of your trial, you have the right to the presumption of innocence. So that means you are considered innocent until the people can prove you guilty. You have the right to require the prosecution to prove your guilt at trial by proving each element of the charge of assault and battery beyond a reasonable doubt. You have the right to confront, cross-examine, and question any other witnesses in court that the prosecution intends to call against you at your trial. You have the right to call your own witnesses to trial or present evidence at trial that you believe further a defense to the charge being brought against you. And you have the right to remain silent at your trial and not have the silence be used against you. Do you have any questions about those rights?
No, Your Honor.
Okay. You will be scheduled for a pretrial conference, and you'll get notice in the mail from the court as to what judge that will be before and the date and time, okay? Have an address here of 3605 Palmer Street as your current home address, but that's the address of the alleged witness, correct? Okay, where will you stay during the pendency of this matter? Because you won't be able to stay in the same place as the alleged victim.
I don't know. To be honest, I don't know. Probably the streets or my sisters.
You said, or your sisters?
Probably. Or the streets. I don't know. Somewhere. I'll find somewhere. I always do.
Are you currently employed?
Nope.
Do you have a phone number?
I do.
What is your phone number? Okay, we need an address that we can send your mail to because that's where we'll send the notice to appear.
Not that I know of.
Okay, so we'll have the notice still sent to the, just so you're aware, there's gonna be a protective order. So if the protected party is going to be staying there, you won't be able to go and get the mail yourself, but you can send someone to get the mail on your behalf, okay? Okay?
Yes, Your Honor.
Okay. Are you currently on probation or on parole?
No, Your Honor.
Is she requesting court-appointed counsel, Ms. Donnelly?
Yes, Your Honor.
Okay, the court will enter a plea of not guilty on your behalf. You can address bond.
Thank you, Your Honor. Ms. Chappelle reports that she has no criminal history. She is from Lansing. I know that it will be problem that she has to solve on where she needs to sleep tonight. That isn't at the Palmer Street address, but I would be requesting a personal recognizance bond because I just don't believe she's a flight risk or that she'll be a danger. Thank you, Your Honor.
Have you missed court before?
Can you repeat the question, please? I'm sorry.
Have you ever missed court in the past?
No, Your Honor.
Okay, she doesn't have any prior criminal history, but there's been multiple charges, all violent in nature, but no convictions. So that is somewhat of a concern for the court, but she doesn't have any convictions. Some of these charges were more recent, which is why I asked you if you've ever missed court in the past. With that being said, I'm gonna need an address within 48 hours, that's business hours, of where you're going to be residing, okay?
Okay, Your Honor.
Bond will be set in the amount of 1,000 personal recognizance. While out on bond, you're not to have contact directly or indirectly with the victim in this matter.
Your Honor,
David Anderson. Excuse me?
Yes, Your Honor. I was just gonna ask, how would I get in contact?
How would you do what?
How would I get in contact with you? Like, do I just call the court and ask for Miss Simmons or?
Well, it's Judge Simmons, but you wouldn't call me because I don't know that you, I don't know, you wouldn't call my office, that is, you never call the judge directly. You would not call my office because I don't even know who this is gonna be assigned to. You could call the clerk's office if you don't have information about what court directly, or you can come up to the court and find out when your case has been assigned and when you need to appear, because you need that information as well, and provide us with an updated address. You can do that right at the criminal traffic window in City Hall, okay?
Okay, thank you, Your Honor.
You're welcome. Okay, so as to your bond conditions, again, you're not to have contact directly or indirectly with David Anderson. So that means You will not have anybody speak to him on your behalf, okay?
Yes, Your Honor.
You're not to be within 1,500 feet of wherever he lives, works, or goes to school. You need to report to all of your future court dates. You're not to use, purchase, or possess alcohol, marijuana, or any other controlled substance unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess a firearm or other dangerous weapon during the pendency of this matter. Do you have any questions about your bond conditions?
No, Your Honor.
Lastly, you're not to engage in any assaultive or threatening behavior while out on bond. Do you have any questions about that?
No, Your Honor.
Any additional matters for the record, counsel?
No, thank you.
Okay, you're all set, ma'am.
Thank you.
You're welcome. Okay, on the record in the matter, the people of the state of Michigan versus Eric Welch, file number is 23-03430. Counsel, can I have your appearance?
Assistant Public Defender Sarah Donnelly on behalf of the defendant for the purpose of Raymond Oliwhite, he appears separately from the Lansing Police Department.
Mr. Welch, can you hear me?
No, ma'am.
You can't hear me?
Now I can. Yes, ma'am.
Okay, thank you.
Miss,
Just listen, just
it's
listen.
important, but before we start.
Just
The
listen.
attorney I spoke with, not my attorney, they wanted me to lie about the day or my address. First thing she said was try to tell me I live somewhere I don't.
Eric.
Hey, just listen. I don't believe.
Okay, Mr. Welch?
Yes,
Mr.
ma'am.
Welch?
Yes, ma'am.
Okay, you spoke earlier with the public defender, okay? I do not want to hear anything that went on in your conversation, okay? Because that's protected information, okay?
It's not my public defender.
You don't own any public defenders, sir.
I know, ma'am, and that
Okay.
public defender asked me to say I live somewhere I didn't, so
Eric.
I can't have that public defender.
Eric.
Okay, well, we can get to the bottom of where you live. I don't see why it would be meaningful for Ms. Donnelly to ask you to say you live someplace where you didn't live, but we'll get to the bottom of your address during this proceeding, okay?
My guess would be that she told him you can't say that you live there, and he misunderstood her. That would 100% be what happened, because she didn't tell him to lie. I know that, but he probably said he lives with the victim, and she probably said, well, you can't say that you live there because you can't be there.
Okay, Mr. Welch, can you hear me?
Yes, ma'am.
Okay.
I want to
So,
go to the hospital.
We will work on that. Let's get this done first and then we will do that. Just focus, please.
okay. Oh, today's the date, Mr. Welch, set for an arraignment. I have here a misdemeanor complaint that alleges that on or about September 2nd, 2023, at the area of which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly contrary to law commit the act in count 1 of domestic violence. The allegation is that you did make an assault or an assault and battery upon a Lacey Rawl, an individual with whom you had a dating relationship. If convicted, restitution may be ordered, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor with a maximum penalty of 93 days in jail and up to $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is, however, a second offense notice. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, or an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating the Michigan Compiled Law 750.812 on or about April 22nd, 2003, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.814 that will enhance the sentence on the domestic violence if convicted to a misdemeanor maximum penalty of 1 year and or $1,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty attached, sir?
Kind of. Yeah, sure.
Okay. You have the right to be represented by an attorney. Mrs. Donnelly from the Office of the Public Defender is here today to represent you only for the purpose of your arraignment. You have the right to have an attorney with you to represent you throughout the pendency of the criminal prosecution. And you also have the right to have an attorney with you to represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the Public Defender's Office appointed to represent you at the expense of the public. Do you understand that right?
Yep.
Is that a yes or no?
Yep. Yep.
Oh, is that a yes?
Yeah. Yeah. Yeah.
Okay, thank you. Thank you. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You have the right to plead not guilty, and you have the right to stand mute. If you stand mute, this matter will proceed to a jury trial, and you have the right to jury trial. You have the right to the presumption of innocence at your jury trial. So that means you are considered innocent, and you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt, and they do that at your jury trial. You understand your rights so far?
I think so.
Okay. Do you have any questions?
Yeah. I would like to know if I can actually have my attorney speak to the attorney that I'll have for this case so I can fully and intelligently move forward and understand completely what's going on. I would like to make the best possible decision, because I don't know what to think right now. I don't know what to believe right now.
Okay, yep, you do have the right to an attorney, and you did speak with Ms. Donnelly today.
No, she has me a lot.
Okay, so you're requesting an opportunity to speak with Ms. Donnelly, or would you like to speak with a different public defender before you move forward with your arraignment?
I would like to speak with somebody who's not gonna ask me to lie.
Okay, she's asking if you want to talk to someone else right now, or if you want to retain a lawyer later.
As long as they don't ask me to lie.
Okay, that doesn't answer the question. Do you want to talk to somebody different right now?
I think I have an answer. So we'll have to reset his arraignment for tomorrow, and then Ms. Donnelly can see if one of her colleagues can come and speak with him, because it sounds like there's a breach of the trust there. And so.
Well, no, Your Honor, I'm the weekend arraignment person too. I've warned him that I didn't tell, and I'm just going on the record. Obviously, I did not tell him to lie. He's misconstruing, and I don't know if he can really understand what's going on. He did
told me I need to give.
He did say some mental health. I told you that you're going to have to live somewhere else. Yes.
Right. That's why you said you need to tell them you live somewhere different. You can't tell them you live there. That's what you said.
Okay. Well, if you don't feel comfortable with her advising you today, sir, your only other option is to wait until we can get another public defender to advise you, because she's the only. This is a holiday, so we're closed, and so we came in especially and specifically for this purpose. And Ms. Donnelly was available to give you advice. From what my understanding is that the advice. This is a domestic violence, and it's standard procedure that if the address of the incident, which is the address of the victim, is also your address, then you're going to need to find someplace else to reside. And it sounds to me like that's what Ms. Donnelly was trying to advise you about. Is that your understanding now?
No, ma'am, she did not say that. She said you need to write a different address. You need to give the court a different address as to where you have been living. That's what she told me. And I said, I can give you an address where I can go, but I'm not gonna lie about where I've been living.
Okay, sounds good. So what we'll do is, if you do not feel comfortable moving forward with your arraignment until there's another attorney, we can postpone this arraignment. You can find your own attorney, you can retain counsel, or we'll see when you can meet with the next public defender that's available. It won't be today, though.
Okay.
I'm inclined to believe it won't be a different public defender tomorrow, but Ms. Donnelly can advise.
I would like a question for the court.
Yes.
Can we set bond? And I
Oh, we won't set bond. We won't set bond until I finish your arraignment.
Okay, we'll finish my arraignment, but we can do it. I don't need a defense attorney. I don't need one to fill in to speak for me as of today. I can.
Okay, so you're ready to continue with the arraignment?
Yes, ma'am.
Okay, very good. So did you have any questions about your rights? Because that was the last question I asked you.
I do have the right to represent myself today and then see the public defender at a later time, correct?
Okay, that's your right. You can waive the representation by counsel. You have the right to represent yourself and you have the right to counsel. So that's your right to decide. And you want to move forward today without the representation of counsel? Is that what you're trying to say?
I would like to move forward today without the representation of Ms. Donnelly.
Okay, sounds good. And you have that right to do that. And so she'll be here on standby should that change your mind change, okay?
Yes, ma'am.
Okay, so back to your rights. You have the right to have a trial and you have the right to jury trial. Again, you have the right to the presumption of innocence at your trial. And you have the right to confront in court and cross-examine in court or question in court any other witnesses or the accusers that the prosecutor calls to testify against you. You have the right to call your own witnesses or present evidence at your trial that you believe further a defense to the charge being brought against you. And you also have the right to remain silent at your trial and not have silence be used against you. Do you have any questions about any of those rights?
No, ma'am. I need a hospital.
All right, well, let's finish this and then we'll get you there.
Okay. All right. Are you okay, sir?
I don't know. I know I need to go to the hospital.
We will take you.
We'll get you to the hospital in just a moment, okay? Okay. And so for the purposes of your arraignment, we're going to enter a plea of not guilty on your behalf. And are you requesting to be represented by a public defender in the future of this matter?
Yes, ma'am. If I can request John Abbott, because he's familiar with me and my situation.
Okay, you can't make a request for a specific attorney, but the public defender's office has their process and they will screen your case and they will assign it appropriately, okay?
Yes, ma'am.
Are you currently on probation or on parole?
No, ma'am.
I don't have a copy of his criminal history for some reason. Have you ever missed court in the past?
Not as long as I was able. Like not intentionally. Like I've had to reschedule court date for.
Okay, what is your address?
It's my understanding that I'm gonna have to stay somewhere different, but the address is currently.
Okay, is that the address that Lacey Raw lives?
Yes, ma'am.
Okay, well then you won't be able to stay there during this matter. So where will you stay?
Yes, ma'am. I'm gonna go to probably my sister's house or a good friend of mine. In Hull. The address in Hull will be, if I go to my sister's, it's gonna be but as soon as I'm able, because I haven't been able to call anyone, I'm gonna call him and I'm gonna call my sisters. If it's not there, it would be more than likely it'll be local. I'll go to Hull, and then if necessary, I'll go to Battle Creek where I'm just not 100% sure everybody's situation, But both places I can go, no problem.
What's your phone number?
I don't know. My phone hasn't worked since Lacey picked me up from CMH. I'm supposed to meet my son the next day. We were gonna go make a report about what happened the day I was arrested. My phone.
So you don't have a phone. You don't know your phone number?
It don't work.
Okay.
You kept telling me it was one. I don't know.
Okay. You're currently scheduled to have a pretrial conference, and it's You're scheduled before Judge Cynthia Ward. It's gonna be on December 11th at 2023 at 10:30 in the morning, okay? Okay?
Okay.
Okay, and we'll get you a copy of your notice to appear. I do not have his criminal history, and so I can't assess, other than the fact that he's being charged as a domestic violence second offense, that there's at least one other domestic violence on his record. Only thing I have before me is the current file, and the affidavit of probable cause. And so based on those things only, I will grant a personal recognizance bond, but with GPS tether. And so bond is set at the amount of 1,000 personal recognizance, and a GPS tether is ordered. You're not to be within 1,500 feet of Lacey Rawl. You're not to have contact directly or indirectly with Lacey Rawl. You're not to talk over me when I'm talking.
I'm sorry.
You need to make sure you appear to all of your court dates, and you need to appear timely. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. Do you have any questions about your bond?
$1,000 or
it's $1,000 personal recognizance with GPS tether.
Okay, so I have to pay it to tell it later. I don't have to give $1,000 to be put on it.
You do not, because it's personal recognizance. You don't have to pay the $1,000. You do have to secure a GPS tether though, okay?
How do I secure?
If you can't afford to pay for the tether, you would have to apply for assistance to have that covered, okay?
Okay.
Miss Donnelly would have more information about how you can apply for that.
Yes, ma'am. Okay. But I'm currently on assistance. I get food stamps.
Okay. So it sounds like you could potentially be eligible, but you would want to speak with Miss Donnelly about how to do that, okay?
I don't trust me.
You're just asking her about where you go to apply. You'll have to get that down at Ingham County though, okay?
Yep.
In Mason.
Okay, I'll talk to the people there.
Okay, sounds good. Do you have any questions at this time?
No, miss.
You're all set.
Thank you.
Thank you.
Thank you. Thank you.
Yes, I was trying to think of the other one. And Letha May, I think, nailed it. I think she got it right on the head. The other thing that I was thinking of was they call it chasing the dragon. It's the, when they smoke H. And yeah. I honestly don't think that there's one that he hasn't liked. So I feel bad for that guy, and I hope he gets some help, because if he doesn't, he's not gonna be on this earth much longer. Yeah, that is a prime example of what that stuff does. I loved that movie. My gosh, you guys are just awesome. I am learning so much about all of you. And you don't even realize that I take notes. I swear, Short Circuit was like the precursor to WALL-E. The person that made the cartoon WALL-E for Pixar, yep, they were a Short Circuit fan when they were kids. Oh my. Wally is amazing. Don't you dare. Love my Wally. And Billy is holding this keyboard down right now. He's so cute, but the whole, like, from the shift enter spot over is inaccessible anymore.
Bennett?
Yeah, Mr. Bennett, please.
Barnett? You say Barnett?
No, Bennett.
You say Barnett?
Hard to call. I've got Bennett.
Barnett.
No,
We're
not
not
you.
Not talking to the jail.
Barnett.
No, there he just came on. So ICF, all right.
No, I don't think that's him. No, JCF. See JCF?
Yeah, Jeannie's is JCF.
ICF must be yours.
That's mine. Bennett.
And the next matter for the court is People versus Brandon Matthew Bennett. It is file 23S30496FH. Mr. Bennett appears by video from the Montgomery County Jail. His attorney, Mr. Norton, is present in court. This is the time and date set for defendant's motion. Mr. Norton, go ahead.
Your Honor, I believe the court has a copy of that motion.
I have it right here in front of me.
And we're going to stand on the motion. My client believes that based upon the Kittle brew that was given, the court wasn't going to follow it, and it was going to give him 12 months with the Department of Corrections. He believes that the court is biased, prejudiced against him, and he's asking the court to disqualify himself in this case.
Mr. Volley. Judge, we really don't take a position on it. I suppose the court feels that it has to recuse itself. It will. Otherwise, leave it to the court. All right. Mr. Norton, until I reviewed your motion, I had no idea that Mr. Bennett had another case here, apparently a civil case. And even if the court had been aware of that, it wouldn't change the court's proposed sentence on the underlying criminal case. And I believe the court, looking at the court notes, stated on the record the reason why it was not going along with the agreement and was going to offer Mr. Bennett a proposed sentence. And again, having placed that on the record, the reason for the court's thoughts as far as the proposed sentence, much of that was discussed as far as his recent parole, criminal history, facts, circumstances in this case. That's all what drives that recommendation, or I guess offer from the court. Court respectfully is going to deny the motion that court does not have any bias or prejudice for Mr. Bennett. Not familiar with Mr. Bennett other than what I've read in that PSI and this new case that is in front of me. So respectfully, I'm going to deny the motion, and can we put this back on for a sentencing date then? 2 weeks.
Did we withdraw him?
I think they withdrew.
I thought we withdrew his plea.
All right, then what do we need to do then to move it forward? Is your client asking for? I have it on for jury selection on my. Perfect. So we're already kind of out of the game.
Yeah, it's on for jury selection. And Your Honor, just so the court's aware, I am not available that day. I discussed that with my client, and Ms. Shearer is gonna do the jury selection for me. And Mr. Bennett, you're okay with Ms. Shearer doing that?
Sure. So make sure I'm understanding you. So Ms. Shearer will be here to do the jury selection. You're still going to stay on?
I'm staying on as counsel. She's just going to cover the jury pick for me.
All right. And Mr. Bennett, again, that's all right. Ms. Shearer will pick the jury for you.
Yes, sir.
All right. That'll keep the case moving along. Then we'll see you. We'll see Ms. Shearer in jury selection day.
Thank you, John.
Can we approach you on? Do we know when that jury selection is? 19th? So January? No.
This is the case in Eagle State of Michigan versus Jacob Hendy, 23S30699. He is appears from the jail. Mr. Strobridge is here in the courtroom. This is we're here today pursuant to a plea agreement. It's my understanding he's going to plead guilty to felonious assault, which I believe is count 2. If he does that, we'll dismiss counts 1 and 3. There's an agreement to jail probation and other intermediate sanctions with a jail cap of 5 months. December plus fines, costs of the students.
It is accurate, Your Honor. So count 2.
Felonious assault.
All right, are you Jacob Hendy?
Yes, sir.
All right, if you'd raise your right hand, I'll have you sworn. You solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can put your hand down. The charge in count 2 is assault with a dangerous weapon. That's commonly known as felonious assault. That's a 4-year felony and/or a $2,000 fine. DNA is to be taken upon your arrest, and a consecutive sentence can be imposed if the assault was committed in a place of confinement. Do you understand the nature of that charge?
Yes, sir.
And do you understand the maximum penalty?
Yes, sir.
Do you understand if you go forward with your plea that you will not have a trial of any kind? Is that what you want to do, is waive your right to have a trial?
Which trial? Oh, yeah. Yes, sir.
All right. Waiving your right to have a trial means that you waive all the rights that come along with a trial. Okay, so Mr. Hendy, here are the rights that you'll be waiving when you waive your right to have a trial. It means you're waiving the right to be presumed innocent of these charges. It means you're waiving the right to confront any witnesses called against you or to call your own witnesses. It means that you're waiving the right to testify at a trial or not to say anything, and the trier of fact could not use that against you. It also means you're waiving the right to have the assistance of an attorney at trial. You may have Mr. Strobridge, he could stay with you throughout a trial and even post-trial if need be. Are you waiving all those rights that would come along with a trial?
Yes, sir.
2 other things you'll be waiving. First one is this: you'll be waiving the right to claim at a later date and time that it was not your choice to enter a plea this morning. Do you understand that?
Yes, sir. Yes.
You'll also be waiving the right to claim at a later date and time that there are other promises or threats or inducements to you except for those already announced on the record. Do you understand that? Do you understand that? So it looks like we got ICF here. All right. Even with your plea, you're going to have a form of appellate review available to you. That's called leave to appeal. With that, you could hire an attorney. If you couldn't afford one, you could request a court-appointed attorney. Do you understand that?
Yes, sir.
You have any questions about anything we've covered so far?
No, sir.
All right, let's talk about the charge in count 2. How do you plead to that charge of assault with a dangerous weapon?
Guilty.
The information says this occurred on or about September 18th of this year in the township of Belvedere, county of Montcalm. Is that the correct date and location?
Yes, sir.
On that date and location, can you tell me in your own words what you did to be guilty of that crime?
I threatened my baby mama with players.
So you threatened who?
My baby mama, my ex.
Your baby mama. Would that be the mother of your child?
Yes, sir.
Okay. And when you say you threatened her, in what manner?
I threatened that I would stab her with players if she didn't leave.
Okay. Did you have a knife in your hand at the time or a pair of pliers in your hand at the time?
You said players.
Yeah, I know, but I'm reading your information. Knife.
They were needleless players, sir.
All right. So I do find that that is enough for a factual basis. Ms. Cross, anything else you want on the facts?
No.
How about Mr. Strobridge? Anything on the facts? No, Your Honor. All right. Mr. Hendy, other than what we've spoke about here this morning, has anybody else promised you, threatened you, or done anything to you to get you to enter this plea?
No, sir.
Other than what we've spoke about here on the record, has anyone else said anything to you about what your sentence would be as a result of entering this plea?
Yes, sir. I think so.
Well, who has told you what your sentence would be?
There's, I was told I'd have a 5-month cap, possibly.
Yeah, we put that on the record, didn't we? 5-month cap? We did, Your Honor. What I'm saying is, besides Mr. Strobridge, besides your attorney, has anyone else said anything to you about what your sentence will be as a result of entering this plea?
Oh, no, sir.
All right. Ms. Cross, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Strobridge?
No, Your
Honor. Ms. Cross, does the court comply with the court for taking this plea?
Yes.
And Mr. Strobridge?
Yes, Your Honor.
All right. Mr. Hendy, do you want the court to accept your plea?
Yes, sir.
I will accept your plea. You did offer your plea freely, accurately, and voluntarily. Sir, I'm going to need a pre-sentence report. That means somebody from probation will contact you to begin the process of completing that report. And once it's completed, Mr. Strobridge will have a chance to review it with you and check it for accuracy. That'll probably occur sometime the day of the sentencing, maybe that morning or a day before or something like that. And then once he has that report and it's accurate, sentencing is generally going to be about 4 weeks from now. Okay, if there's nothing else, that'll conclude the matter.
Thank you, Your Honor.
My favorite types of shows are, I think they're called psychological thrillers. So there's one on Hulu called Flesh. That was pretty crazy. And then there is Dexter. Oh, I loved Dexter. The types of movies that scare me are not horror movies. Not at all. They're the ones that are with crazy people, because those ones could really happen. And those are the ones that I absolutely love watching. The ones that keep you on the edge of your seat and really make you like check to make sure your doors are locked at night because they scare you that bad. Those are the ones I love.
Lori, you want to do where?
Yeah. This is one we got to talk to him about. We talked about this yesterday.
We'll talk to the judge.
Yeah, and probably next then.
Our next matter for the court is People versus Christopher Lee Johnson. It is filed 23S30637FH. Mr. Johnson appears by video from the Montcalm County Jail. His attorney, Mrs. Shear, is present in court. I've had the opportunity to speak with Mrs. Shear. My understanding is Mr. Johnson wishes to take advantage of the plea offer. He would plead to count 1, which is possession of methamphetamine. We have an agreement that he would serve 14 months in the Department of Corrections. We are waiting. He would not. We are dismissing the individual.
Correct, Ms. Shear?
That is correct, Your Honor. And Mr. Johnson is on parole, so this would be a consecutive sentence.
Correct.
All right. And then, Mr. Johnson, that's your understanding of the agreement?
Yes, Your Honor.
All right, raise your right hand. I'll have you sworn. You solemnly swear from testimony you're about to give me the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, you can put your hand down. So the charge in count 1 is possession of methamphetamine. It's a 10-year felony and or a $15,000 fine. Do you understand the nature of that charge?
Yes, Your Honor.
And then do you understand the maximum penalty is up to 10 years?
Yes, Your Honor.
Do you understand, Mr. Johnson, if you go forward with your plea, you won't have a trial of any kind? Is that what you want to do, is waive your right to have a trial?
Yes, Your Honor.
Waiving your right to have a trial means you'll waive all the rights that come along with the trial. I'll describe those to you now. It means you're waiving the right to be presumed innocent of the charge. It means that you're waiving the right to confront any witnesses that would be called against you or to call your own witnesses. It means that you're waiving the right to testify at a trial or not to say anything, and the trier of fact couldn't use that against you. And it also means that you're waiving the right to have the assistance of an attorney at a trial. You have Ms. Shear. She could stay with you throughout a trial and even post-trial if need be. Are you waiving all those rights that would come along with a trial, sir?
Yes, Your Honor.
All right. 2 more things you'll be waiving we have to discuss. The first one is this. If you waive your right to have a trial, then you're also going to be waiving your right to claim at a later date and time that it was not your choice to enter a plea this morning. Do you understand that?
Yes, Your Honor.
Okay. Waiving your right to have a trial means you'll also be waiving the right to claim at a later date and time that there were other promises or threats or inducements to you, except for those that we've already announced on the record this morning. Do you understand that? Mr. Johnson, do you understand that?
Your Honor, can I speak?
Yeah, go ahead. You might want to check with Ms. Shear, though. We don't want you to say something that
Don't do
could
it.
make things worse.
I don't, no. It's been brought to my attention that my attorney and also from my family that Mr. Valet has a biased opinion about me and refuses to give me a fair proceeding. Mr. Valet was the prosecutor for Brandy Jones' case that she just got sentenced to 12 years.
Mr. Johnson, why don't we stop a second? Mr. Valet is a prosecuting attorney. So
Yes,
whether
exactly.
he has a bias or a prejudice against you, first, I don't know that I buy that, but even if he did, he's the adversary here. So he is the part of the executive branch, and they're free to offer or not offer anything that they would like to do as the prosecuting attorney's office.
So I can't speak.
Well, you can clear it with Miss Shear, but I think you're just in general, you're kind of barking up the wrong tree, because the offer that was placed on the record today is, I must see this 1,000 times, both in Ionia and Montcalm County. I'm charged with meth, they dismiss the habitual offender. Happens every day.
All right, yeah. I'm good.
Well, let's just circle back then. So the question that I was posing to you that was troubling you was the question, do you understand that if you waive your right to have a trial, then you're also going to waive your right to claim at a later date and time that there are other promises, threats, or inducements? That's a long way of saying that if you go forward with your plea today, you can't come back later and say, hey, wait, there were other promises that were not placed on the record. For instance, if I pled, if I'm on probation, they're going to give me a $30 voucher every month so that I can go buy cigarettes. Something like that, right? Are there any other promises or inducements to you?
No.
Okay, let me put it another way. Are there any other, what you would perceive as threats to get you to enter this plea? Mr. Johnson, you seem troubled. Listen, you don't have to enter a plea. You can have a trial.
I guess. No, Your Honor, there's not. No.
Do you want some time to talk to Ms. Shear? I don't want you to rush into something. If you'd rather have a trial, I'll schedule it for a trial. And you can explain your side to the jury, and then the jury will listen to both sides, and then they'll make a determination. Or you can have a trial in front of me and I'll listen to both sides and I'll make a determination. Whatever you're most comfortable with. You don't have to enter a plea.
No, Your Honor. I'm good. I'm going through that. I apologize.
So let's circle back then. Again, have there been any other promises or threats or inducements that are getting you to enter this plea?
No.
All right. So let me think. So we left off with, all right, all the things he's waiving. So then the next thing is, Mr. Johnson, even with a plea, you'll still have a form of appellate review available to you, and that's called leave to appeal. With leave to appeal, you can hire your own attorney. If you couldn't afford one, you could request a court-appointed attorney. Do you understand that?
Yes, Your Honor.
All right. So let's talk about that charge now. Mr. Johnson, how do you plead to the charge of possession of methamphetamine?
Guilty.
All right. The information says this occurred on or about September 18th of this year in the township of Eureka, county of Montcalm. Is that the correct date and location?
Yes, Your Honor.
On that date and location, can you tell me in your own words what you did to be guilty of that crime?
I got pulled over. And he searched the car and he found a bag with some residue in it, and I'm guilty of possessing meth.
All right, so driving a car, was this your car?
Yes, Your Honor.
All right, and found a bag. Where did they find the bag? Do you know?
The passenger seat.
Okay. And in the passenger seat, it had residue, and was the residue methamphetamine as far as you were aware?
Yeah.
Okay. Mr. Blake, anything else on the facts?
No, Your Honor.
Ms. Shear, how about you?
No, Your Honor.
All right. Mr. Johnson, again, has anyone else, or has anybody, let me put it this way, has anybody promised you, threatened you, or done anything else to you to get you to enter this plea? Excuse me?
No.
Okay. Has anyone besides Ms. Shear, that's her role as your attorney, to tell you the different options and what she thinks could happen, or what you'll ask for, or what the people would ask for, but has anybody else besides Ms. Shear said anything to you about what your sentence will be as a result of entering this plea?
No, Your Honor.
Okay. Mr. Vlay, are you aware of any other promises, threats, or inducements?
I'm not.
How about you, Ms. Shear?
No, Your Honor.
Mr. Vlay, do you believe the court's complied with the court rule for taking a plea?
Yes, Your Honor.
And Ms. Shear?
Yes.
Okay. Mr. Johnson, do you have any questions now that we've almost completed this process?
No.
All right. Mr. Johnson, the last question I have for you. Do you want the court to accept your plea to this charge of possession of methamphetamine?
Yes, Your Honor.
All right, we'll accept your plea. You have offered your plea freely, accurately, and voluntarily. Sir, we're going to need a pre-sentence report before sentencing. That means somebody from probation will be able to talk to you. Once that's completed, Ms. Shear will get a copy of the report, and she'll be able to go over it with you so we can check it for accuracy. That report generally takes about 4 weeks, so we'll have a sentencing date about 4 weeks from now. Anything else from either side?
No, Your Honor.
No, thank you, Your Honor.
Okay, you're all set. Thank you.
Next.
Okay, you guys, I need to know. Do y'all think that that guy was acting to be able to toy with like the deal later? And if you hear a thump thump thump, and my daughter's using a sewing machine, so it might make some noise. But that guy was just, he was acting so weird, and I don't know if his weirdness is his personality because of the drugs, or if his weirdness is that he's trying to put on a show of how affected he is now, you know, like the prosecutor did him so wrong, and that way he can file an appeal and he can be like, you know, see, watch how I was when they were taking the deal. They wouldn't even let me talk, and I was so upset. And you know, I mean, I don't get this guy, other than like, I don't know if he's honestly that genuinely upset by the prosecutor having a bias towards him, or if it was all show. I don't know. Yeah. Could be. It could be a mix of both. You're right. Yeah. Yeah, it could also be that he didn't want to admit that he was guilty of it, and I don't know. He seems like one of those put all the blame on everybody else kind of people, as it is. Yeah. It could be. Could be. That one just got me. That one just, I can usually get a pretty good read on what's up with them. I couldn't get a good read on him, but I definitely think he's a manipulator. I guarantee he's a manipulator. And he has that kind of vibe that he thinks he's every woman's dream. Sorry, he's not. He's got to get into a turtle suit for that. But I bet he's gotten through most of his life manipulating people. And I think he thought he could manipulate the drugs with that whole, the prosecutor's out to get me thing. Well, yeah, the prosecutor's out to get you. That's his job.
Matter for the court is People versus Justin Allen Lamar, this is 23S30032F8. Mr. Lamar is present in court, along with his attorney, Ms. Reed, for sentencing.
Okay, Ms. Reed, have you had an adequate opportunity to review the pre-sentence report and the sentencing information?
This one hurts, y'all.
Why?
Yes, Your Honor.
Additions, corrections, or deletions?
No, Your Honor.
None?
No, Your Honor.
Okay, then you believe we have accurate information on which to base sentencing?
Yes, Your Honor.
Okay, then Mr. Valet, anything on behalf of the victim?
Yeah, we have a victim here, Sergeant DeWitt is here.
Okay, Sergeant DeWitt, if you come up, and then Mr. Lamar, you and your attorneys can have a seat at the table.
Morning, Your Honor.
Good morning, how are you?
I'm doing okay.
The man bun isn't even the part that hurts the most.
What did you want to say this morning?
Well, I appreciate the opportunity. I'll start by saying I've been a police officer for 33 years. I've been a firefighter for over 10. And this is the first time I've ever spoke at a sentencing. First time. And there's reasons for that. One of the things I'm here today is talking and convey how serious my injuries are. I don't think they've been conveyed. And it's understandable. This incident is absolutely ridiculous. It's just, he's being placed under arrest for the most minor charges possible, and he chooses to react in a violent manner. Violent. For what? For a jaywalking ticket warrant that he did contempt of court? And I'd like to say that he made that decision, but I don't think he even makes decisions. I think these are reactions, and that makes him even more dangerous. So during this resisting arrest, I get assaulted, I get injured. It's a violent scuffle. We're on the ground. There's another officer involved. We're there. To make it even worse, during the scuffle, I look over, and I know that you weren't allowed to hear this, but I look over and here's a gun on the ground. His gun. So now am I fighting this guy? I go through can you imagine the trauma? I mean, it's a pretty big deal. You look over and there's a revolver pointing at you within reach. So I'm not having a friendly scuffle. This isn't just exercise. This isn't just doing my job. Now I'm potentially fighting and thinking I could be seriously hurt or killed here. Now it turns out, for whatever reason, it ends up being some kind of pellet or BB gun, but I'll tell you, it's the most realistic revolver I've ever seen that wasn't real. I could put it on the table and challenge anyone to say, is that fake or real? And they wouldn't be able to tell. I don't think he even understands. Why was he carrying it? I don't think he understands if that came out 10 seconds earlier, 20 seconds earlier, we may have a very different outcome here, because that, to me, was a real gun. So the scuffle, and then he's threatening to taser us for some reason. I'm not wondering, does he have a taser? Is that another weapon involved here? So I get injured. At first you're like, well, it's just another injury. And I get it. Some of it's a little bit about, police officers get hurt, it goes with the job, but I don't agree with that. But I'm suddenly realizing my left knee is very painful. It's not right. I had an ambulance come to the scene, check him, but also check me for my injuries. Ripped uniform, broken eyeglasses, abrasions, cuts to my nose. My knee is swelling up. Then I went to the emergency room that same night for the same reasons. This starts a cascade where I'm not healing up. I couldn't tell you how many doctors I've been to in the last 9 months. A dozen, 2 MRIs, physical therapy twice a week since this happened. Still, twice a week physical therapy, and I do physical therapy at home twice a day. I'm trying to get strong or stronger than what I was. This ended up in October, once the initial injuries were healed enough that they did another MRI and could see there was more damage. I had to have a surgery. I had an operation on October 2nd. I can't even pronounce the medical terms of what they did to my knee. I have them if you'd like to see them, but I can't even pronounce them. It's about 7 procedures. I was on the operating table for a long time. And thankfully, I can walk now better than what I could. Now, I am in pain 24 hours a day. It never goes away. It is better after the operation. I would even say tolerable. Walking, I'm pretty okay. Can't do a whole lot more. I can't run. I can't climb a flight of stairs quickly. I can't climb a ladder. I can't carry heavy weights. Twice my doctor has told me you might have to consider that you may not recover enough to go back to work. Now, I have a hard time accepting that. My next appointment's the first week of January. I'm hoping for the okay to go back to work. The alternative is just not acceptable. I can't imagine it. Financially, workman's comp is about 50% of what I make. My monthly expenses are usually more than what workman's comp pays. My tax bill came yesterday. It's well above what I get from workman's comp check. I have to dip into savings to make these bills, and that can only go for so long before that's not working out. I'd rather been hit by a car. At least there would be some repercussions, and I could look at lost future income, et cetera. But I have submitted a restitution request, and I was generous on this. I did not factor average amount of overtime or holiday pay or anything like that. I factored in my normal pay. Comp pays, and that's the difference. And I calculated out to the first week of January. I started another job. This is a career. And yet I have, it's all unknown. I would love good legal advice about where to go from here and what the possibilities are. I haven't been able to find it. I've reached out, not getting a lot of answers. You have to make a decision today about his sentencing. And I would encourage you to look at the criminal history. Look that he's had breaks, he's had opportunities. His first felony was cutting his tether off. That should have been a sign right there. He's not going to comply or follow the rules of parole or prison or anything else. He served time in prison for causing injuries to a police officer. Now, maybe you can't go by it, but if you look at the original charge, it was for also being arrested for attempting to disarm an officer. He has a previous home invasion second that was pled to something else. His history is not, you can guarantee this isn't going to be his last one. He's not going to change at this point. He served time in prison. He was out for 1 month. 1 month is all he made it before violently reacting and committing 2 more felonies. By my count, this is his 6th felony and about 8 arrests. And he's only 26 years old. I mean, if there's an indication of past performance, of future performance, this is it. If you handed me a hammer and I hit somebody in the head with it, and I do that a 2nd, 3rd, 4th time, by the 5th time, I would think you'd stop handing me a hammer because you know what I'm going to do with it.
I would agree with that, but have you been paying attention to the direction of the world as it relates to criminal justice policy?
I have.
It's not pro-police friendly. It's not victim friendly.
No.
It's not society friendly.
And I get that. I get the Constitution's written 100% for the rights of the accused, none for the victim. I too have studied criminal justice around the world. I've seen the comparisons, and I agree with that. And I know, realistic enough, that you personally right now can't affect crime across the United States, which I consider the biggest problem facing our country. To a lesser extent, you can affect a little bit in the state of Michigan. But what you can affect 100% and immensely is Montcalm County and Ionia County. You have that authority right here. I don't see any miracles here. He's been given alternative to prison programs, the tether. He's given parole. Parole's not mandatory. They come to you and say, you're eligible for parole. Would you like it? If you do, here's a list of rules to follow, and they're really easy. Sign here. He asked for parole and he made it 30 days. I mean, you know how much effort I do every day to stay out of trouble? 0. It's no effort to stay out of trouble and not commit crime. It's 0 effort. So I'm here to tell you, this isn't just a scrape. This wasn't just a boo-boo. This may be a career-ending injury. I've been out of work for 9 months. I've fallen in front of my child. My son has to pick me up at times. Can you imagine the look on his face when he picked his dad up? Yesterday, I stepped out of bed, my knee locked up in a 45-degree angle. It was like that for an hour. So much pain, I couldn't bear it. I couldn't walk. An hour later, it finally broke free. That's the 3rd time it's happened in the last 6 weeks. I'm working, I'm trying to get healthy, I'm doing what I can. I take my bumps and bruises pretty good over the years, decades, but this is beyond. This is more serious, and I just want you to know that this is possibly lifetime, and I guarantee it's lifetime. The doctor already told me, like, no matter what, you are going to get arthritis in that knee early, and it's always going to bother you. Okay, but can I go back to my career? That's questionable. I find out in a few weeks. If not, I don't know what to do. So I'll sum it up. I can go on and on, but I'm bluntly asking you to exceed the guidelines. He doesn't deserve minimum guidelines. He doesn't deserve the low end of it. He's had those. And he hasn't done anything. I feel my opinion is why he's out, he's going to commit crime. But I guarantee you why he's in prison, he's not committing crime against us. So again, bluntly, I'm asking you to exceed the guidelines, sir. And I appreciate you listening.
Thank you.
Thank you.
Mr. Blade, do you have anything else on behalf of the people? And then
I'd like to talk about the recommendation here. I too do not believe that this is appropriate. Mr. Lamar is a problem.
Hold on, Miss Reed, and can your client come back to the podium?
Your Honor, may we proceed from the table with both Kyle and I? It works so that we have more room to sit next to our client.
That's fine. If you'd rather stay there. Mr. Lamar, do you want to stay there at the table?
Or would you like to go up to the podium?
Sir.
He would like to stay at the table with the.
You want to stay there?
Yeah.
Okay.
Thank you.
Go ahead, Mr. Blade.
So I think the recommendation in this case is inadequate. The guidelines here are 14 to 58. This court has discretion to run these consecutive, and I'd urge you to do so. And here's my basis, not only for what Mr. DeWitt has already told you about his injuries and the like, all of which are serious. I agree with him really strongly about one thing. You can look at Mr. Lamarck's history, and he is a problem. And he's right. Sergeant DeWitt's right. A month, he gets paroled. For the very charges that he's here on today. I don't know, what didn't he get? He spent 23 months in prison. What didn't he get? And he wasn't there for one case, he was there for multiple cases. He was on parole for two offenses that he was in there and got out on. But he has just since 2020, he's been arrested for resisting and obstructing 3 times since December of 2020. Sergeant DeWitt is right. If we leave him out, he has no regard for the law, and his modus operandi is what we see him do is that he is going to resist officers, and that creates a public safety risk for everyone. It creates a problem with the officers. Sometimes we hear rightfully or wrongfully about the terrible things that officers do in the community. But if this is the type of behavior that they have to deal with, one can, from their perspective, see why they're on edge, why they have to be worried about someone just like Mr. Lamar. And I agree with his statement about the gun. Mr. Lamar is lucky he didn't get killed. That is the simple fact of the matter here. While that wasn't a criminal offense in this case, what does Mr. Lamar need to be carrying around a real looking pistol for? Quite frankly, it's like my mother used to say, anything that happens after midnight is probably going to get you in trouble. Walking around with a pistol.
Said that. So
did my mother. I'm not sure which one was first. But this is a guy who's taking, that can only go badly. Something is going to go wrong either for Mr. Lamar or it's going to go wrong for someone else. That's the only reason that particularly a person in his position would be carrying this around. So I agree with Sergeant DeWitt. If you look just in the last 5 years, he's out of control. He has cut his tether off. He shows his disregard to the court. He continues to use alcohol. He continues to, he's exporting his crime. He goes to California and he's committing offenses in California while he's there, all in this 5-year period. So I think the recommendation here, while normally would be right in the middle of the guidelines, I'd ask you to consider a much higher sentence. And I also think that you have the right to, this is certainly going to be consecutive to his previous sentences that he was on parole for, but that you can consider giving him 2 sentences, 1 for each charge. The law certainly allows for you to give him consecutive sentences. And I think we're to the point with Mr. Lamar that housing him has now become what we have to do. He has shown that he is unwilling to follow the rules of society. And the last thing I'd say is, I think Sergeant said it very nicely in the sense of it isn't hard to stay out of trouble. In this case, Mr. Lamar has the assistance of parole to help him along these paths. There are people there who can help him with, if he's got alcohol problems, if he's got these things, I need trouble, difficulty finding a place to live, I'm looking for employment. He has a lot of resources that the normal person in the population doesn't. He chooses not only to throw those away, but he chooses again and again and again to do whatever he wants. And I think we're past the point of trying to fix Mr. Lamar. We're at the point where we're talking punishment more than we're talking reformation. I hope he gets it. He's a young man. He has still a lot of life in front of him, but the way he's going, I don't see how he's not going to be spending it incarcerated, because he's forcing us in that direction. So I'd ask you to exceed this guideline. I believe, or not the guideline, exceed this sentence. If the court's so inclined to either consecutive sentences, but I would think that this is much closer to a 5-year sentence than it is a 3-year sentence.
So
he's going to spend it either incarcerated or 6 feet under, because those are really the only 2 options for the choices that kid is making. And I don't know what causes someone to make those types of choices in the way that he's making them, but it's ridiculous. And it needs to have a stop put to it. And if he's not strong enough to have the stop put to it himself, then the courts need to be the ones to put the stop to it. Because the community is not safe with someone like that. Every single time an officer gets near him, he flees and causes a ruckus around it. One of these times he's going to run over a small child on his path to freedom. Yeah, he needs to be put away. That's the only way to keep the community safe.
Ask Ms. Vanderveen and then I'll let you weigh in. So the guideline range here is 14 to 58. Now that's in essence on what's in the information count 2, which is the resisting, obstructing, causing injury. But we have 2 counts here that he was convicted of. And the first one is simply the R&O. What are the guidelines on the R&O? Are they the same as the causing injury?
I scored it, and we agreed our scoring and agreed on the other one. I have him at 7 to 46 on G grade.
That's probably accurate then. We're not required to score the second as long as the one is.
Well, so here's what I'm thinking though. So I think that might be useful to the court, and let me just give you the court's thought on this, which is why maybe we need a score as part of the record, because he's going to have an automatic right to appeal. I'm not going to give him an automatic right to appeal by exceeding the guideline. So the smart way to do this in my mind, and this is where the court is inclined to do. Now I haven't heard from the defense. I haven't had the benefit of your allocation, but I'm going to give him a consecutive sentence. That would eliminate his right to appeal on the sentence. He's going to have a right to appeal for the underlying trial. But in order to give him a consecutive sentence, I feel like I really do need to know what the guidelines are for count, in this case, 1, as opposed to count 2. You believe they're what, Mr. Valet?
I have him at 7 to 46, and I can tell you the scoring on the top is the same. It's 87. He's an F on his prior record variable, and I have him at he's either got 35 to 50 points depending on the court, and that's the same bracket, which is F3. F3 is 7 to 46 as a habitual.
The last thing I want to do is adjourn this, but I think for appellate purposes, because my goal is to craft a sentence that we make as appellate proof as possible. What I would propose, and I'm certainly not going to make the officer come back, we run the guidelines for the second one, that they can have an opportunity to review it and object to any scoring issues with it. And then for appellate purposes, we have scoring guidelines on both counts because the court is considering running them consecutive and thereby doing it in a manner that eliminates as many appellate issues as we possibly can.
I will point out, Judge, which haven't been, my understanding is objected to now, the scoring in this case would be the 25 points in an OV 13, which is already scored here for the pattern of continuing criminality. The only difference is in offense variable 19. In the one with injury, he gets 15 points, and without the injury, he gets 10 points. That's the 35 points, and he has it. So, I mean, if you want to do that, that's fine. But those two, which they're not objecting to, are the scoring pieces.
No, I would concur with that. I just think we need a paper record for appellate purposes so that we can do this as cleanly as we can by dotting our I's and crossing our T's. And then I certainly am interested in hearing what Ms. Reed and Mr. Stourbridge has to say. And then the court will fashion what it thinks is an appropriate sentence, but just, I don't want to mislead Ms. Reed, or I'm considering running this consecutive. I'm considering doing that for a host of reasons, which I can place on the record. But first and foremost, I want to have accurate guidelines so that the court can consider a consecutive sentence, which makes more sense to the court rather than adding more appellate issues to the mix, so to speak.
Your Honor,
And actually,
I would actually appreciate the extra time considering what you put on the record so far. I just want to note that my client's on dead time, so would the court be willing to consider giving him credit for the time between now and?
No, why would we do that? He was on parole. But what I would do to accommodate you, Ms. Reed, is today is Thursday. I don't want to put Ms. Vanderbeek under the gun, but I have tomorrow. So tomorrow I'm supposed to be in Ionia, but I certainly could sentence him remotely if you all want to be here in the courtroom, and I could just do it from Ionia, and then he doesn't have to worry about sitting on the downtime. I don't want to put pressure on Ms. Vanderbeek, but I think we're all in agreement that that's just simply running a piece of paper and plugging in the numbers and just getting it so that it could be reviewed.
Yeah, it should be done today.
And then Ms. Reed, assuming that I can do that, or you're interested in that, the one thing that would be important to the court is you identifying that if Ms. Vanderbeek is able to put this together, that you've had an adequate opportunity to review the scoring issues, and that there wouldn't be any.
Yes, Your Honor, I will get it reviewed today, and I am available tomorrow.
Okay. So why don't we plan on that? And I might even be able to work on it. It's not going to work this week. I might be able to come work it out. I'll let my office work it out with you guys. I was thinking maybe I could come up first before I go to the Ionia meeting, but maybe I'll have to do it after. We might. Are you available in the afternoon?
I'm here all day.
Are you available?
Dedicated public term.
Like it'd be early afternoon. What about you, Ms. Reed? Are you available in the afternoon? And Mr. Stourbridge?
I'm available all day, Your Honor.
Perfect. Ms. Reed?
Yes, Your Honor.
Okay, and I think that makes good sense. I don't want him sitting on dead time if we don't need to do that. Okay, so we'll work it out for tomorrow. Officer, you do not have to come back, but you're more than welcome to, or you can appear remotely, whatever works for you. Okay.
Young, this is a case of the people versus David Cornelius Barnett, 23S30356FH. Hearing by Zoom as his attorney, Joseph Brunelli is also.
Good morning, Honor Joe Brunelli, appearing on behalf of Mr. Barnett.
All right, Mr. Brunelli, have you had an adequate opportunity to review the pre-sentence report and the sentencing information with your client?
I have, Your Honor. I've received that. I've gone over it. I've also forwarded it to Mr. Barnett, who is currently in Harbor Hall. And from my understanding, everything is accurate.
So no changes. You believe we had accurate information on which to base sentencing?
That's correct, Your Honor.
All right. And then I'll start with the people. Mr. Corbett, anything on behalf of?
Your Honor, I have no additions or corrections. I would ask you to follow the recommendation.
So let me ask you this. I looked at this one carefully. We've got a guideline range of 10 to 28, 6 prior felonies, 12 prior misdemeanors. This morning, I looked at it again. I was trying to add up how many times he's been to prison. It looks like at least once, and I thought I had read, or twice, if you count, because it's interesting, Illinois, that 11 of 18 says 12 months on aggravated use of a weapon. It's like a low severity felony. So I assume that means prison in the same manner that we would consider prison as a 1 year sentence. So that means he's been to prison at least twice. The other concern I have about this is that he has a number of assaultive type crimes. The other concern that I have is that as recently as 2021, we had a drunk driving that just resulted in 5 days in jail and 12 months of probation, which is, I recognize it was only a second offense at that time, but seems so insignificant compared to his history at the time. But also it demonstrates to this court that Mr. Barnett got absolutely nothing out of that most recent supervision, which I have to assume on a OWI second, he was required to do and engage in supervision of a nature that include counseling, random drug testing or alcohol testing. Looks like he, in fact, I should say it looks like, but there's no narrative for that. So I don't know if he successfully completed it, didn't complete it, but whatever the case may be, we utterly, meaning we as a criminal justice system, utterly failed with that opportunity, because here we are now on a third offense. And then most importantly, I don't see allowing him in sobriety court that we're going to change anything. When I look at the Compass scores for this guy, he has almost no employment history, even though he's 43 years old. And then if I'm in Dubai, I mean, I suppose Department of Correction puts a lot of time and stock in their Compass narrative. But if we do, that seems to suggest that he's at high risk for reoffending if he's in leisure or recreational opportunities, social isolation, and substance abuse. But all of those things are going to come to the surface when I got a guy here who just doesn't work. He has no real employment history. So he is going to be doing nothing. He is going to be around people in social settings. And I can almost guarantee he is going to reoffend. He's going to put somebody in danger. So that's a long way of the court saying with these guidelines and this history, I'm not comfortable with this jail sentence and sobriety court. I think, Mr. Bergali, that the court's proposed sentence here would be a prison sentence, and with a guideline range of 10 to 28. In his history, I'm willing to stay in the middle of the guidelines at 19 months, but I cannot go along with this agreement because it strikes me as a ticking time bomb. We've given him supervision. We've given him probation. He's been to prison before. None of that has worked. In my estimation, this PSI simply says, who's the next victim if I go along with this agreement? So do you need some time to talk to your client, or I can even adjourn it for 2 weeks?
I probably will, Your Honor. I mean, we were fully anticipating him participating in sobriety court. He's been in, voluntarily was able to get into Harbor Hall on his own, and I think that's part of the failure, not on the court system, but on my client's failure to recognize his substance abuse issues. And I know he did have the one relapse while on bond, and he did the 77 days. But I think prison is only going to set him back. I think what he needs is treatment. And then from my understanding, he hasn't had that opportunity. And now that he's got 34 days in Harbor Hall, he's at least.
Yeah, but let's, I don't buy that at all, counsel. I know that you're advocating for your client, and you should. He was just on supervision for operating while intoxicated, second offense, just on supervision. And I am not going to buy the idea that he wasn't given the opportunity, probably the mandate with supervision, to engage in counseling services to address his addiction. I agree with the idea that he needs to get a hold of this. However, unlike Harbor Hall, the Department of Corrections has medically assisted treatment. They have all kinds of programming to address this. There's also a component of punishment here and protection of the public. And for all the reasons I've stated on the record, it's not often that I find myself in these situations. I'm a proponent of giving folks the opportunity to engage in specialty courts. I'm a proponent of giving people the opportunity to get help, but not when I look at this history. When I look at this, again, it's a DOC's compass score. I mean, that to me screams, with his history, he doesn't work. We're going to be right back here. I'm not going to be in a position where I have somebody hurt or killed because your client can't get it together. So I'm comfortable. I know that for the next 19 months, you can't hurt or kill somebody. And I know the Department of Corrections will be tasked with addressing the underlying issue amongst others. So what would you like to do, Council? You want to adjourn for 2 weeks or not?
Yeah, I think that would be appropriate. I'm just pulling up my calendar right now. So that would put us at is that the 20th?
That'd be the 21st.
21st. So if I have to be in the morning, I have to be in Baldwin at 1 o'clock in the afternoon. So if it's in the morning, I can do the morning.
Yeah, it would be same, just like this. And if you need to get going, we could probably call that one earlier in the morning. That's not a big deal. And you could even appear remotely if you prefer, if that makes it easier for you. I don't know what kind of reception you're going to get up in Baldwin, but maybe if you're at the courthouse, you'll have a good connection.
Sure. And so I know he's at Harbor Hall. So as far as bond, I would assume when he's done with treatment, if it's within the 2 weeks, he just obviously comes to court.
Well, that's a very important thing to talk about. So he can remain at Harbor Hall, but when is his treatment supposed to end?
Pretty soon, within the next week.
Yeah, I can't have him out then unless he's in a residential setting like that. I'm not going to give him the opportunity to do something stupid, especially when he now knows the court is considered a prison sentence. All right, so Mr. Barnett, you can continue at Harbor Hall, but once that program is completed, then you're going to have to report directly to probation for a tether. Expect that you will be tested for drugs or alcohol when you show up for that tether. The other thing is, sir, I want to have in writing to my probation department when you are expected to be released, and then you'll have on that date just a couple-hour window to get down here and be fitted for a tether, Ms. Van.
The tether has to be placed by community corrections, so only to those states.
You're right, because he's not on supervision. So let me just clear that up. Community corrections, what are their hours? Anybody know?
Yes.
It's 8 to 4. 8 to 4, Monday through Friday. So that'll have to be done through community corrections, and you report to the jail for that. And it's Mr. Everything, correct?
What were the hours again, Your Honor?
8 to 4.
8 to 4.
And so, Council, you could probably contact Mr. Everingham and give him a heads up and smooth the way so that your client can be there and be there timely. All right.
Okay. All right. Thank you, Your Honor.
All right. That'll conclude the matter. Well, we've got Mr. Burns here.
Good morning, sir. I'm sorry. I thought you were going. We have Robert Minima at the jail, please. Yes. Your Honor, this is the case of People versus Robert Francis Minima, case number 23S30324FH. We are here for sentencing Mr. Minima.
All right, Ms. Reed, have you had an adequate opportunity to review pre-sentence report and sentencing information with your client?
I have, Your Honor.
All right, do you have any additions, corrections, or deletions?
No, Your Honor. Except that I would like to note, I believe that we made some arguments on the record at one of the prior scheduled hearings about the guidelines. I'm not gonna repeat all of that now.
Well, we ruled on those, right? It was OB 14 and then PRV 7, and the court made a decision on those?
That's correct.
Okay, very good. So then you believe, as far as today is concerned, and recognizing the court has already made rulings on your OB objections, that we have accurate information on which to base sentencing?
Yes, Your Honor.
Okay, then I'll just simply start with People and or I do have probation here as it relates to he has been accepted into Swift Insure?
At your request, Your Honor, I viewed him, yes, and he had to take care of the case in Kent County, which was 6 months served, and which made him eligible for Swift Insure.
So what are your thoughts then on a jail sentence today, recognizing if he's been over there 6 months, or maybe not, I don't know how long has he been here, what do we got for credit, it was 94, so I assume that's probably 164. So Mr. Burns, what do you think as far as
I would go with the standard 10 months.
The 10.
You know, and then we'll start fresh.
Okay. All right, and then Mr. Corbett, anything else?
Your Honor, the middle of the guidelines is 111 months. With his record, I don't see him being successful at Swift Insure. We should just sentence him to prison, to be honest.
See, that's what I like, because that's what I'm thinking. But it's great when you go, and you're gonna say he's great, and then I can be in the middle, and I don't have to say that, even though I might be. All right. Ms. Reed, anything on behalf of your client?
First, I guess I would go back and ask that the report be corrected to update the jail
164.
credit. Yes, thank you for bringing that up. My client is incredibly grateful for the opportunity that this court has offered to provide him. We're asking the court to give him that opportunity today. I understand there's some skepticism around the room, whether, regarding my client's ability to succeed. But that is going to be up to him. And he's already demonstrated how motivated he is by getting a bed lined up for himself at Randy's house. He was residing in Montcalm County, would have qualified for Swift Insure regardless, but he's making that choice to set himself up for success. He's participating in a recovery program in the jail. He's got a recovery coach through the jail. He also has a full-time job lined up for when he's released. I believe that he's truly remorseful. And again, incredibly, incredibly grateful for this court offering him Swift Insure.
All right, and then Mr. Minima, anything that you want to say to the court before sentence is imposed?
Just that I really took, what you were saying, giving me a chance and a consideration, and I have, I didn't want to leave it at the discrepancy of, just having a normal address, so I took it upon myself to try to enter into a recovery program, and they did get me a bed open and ready to go. And I've also entered into the MRT program, and I'm already on the third phase of that. And both Dusty Gibson and my recovery coach have went out of their way to pull some strings for me to get me into the recovery house. And I know you've probably heard this before, Judge, but I'm not going to let you down. I want to do anything I can do to make a positive influence on the community that I affected.
All right, well, Mr. Min, I hope that you comply with that and that you follow through with what you're saying here and looking at this again. The only reason that I was so interested in this is it's somewhat frustrating when you sentence people week after week after week and you have instances where guidelines are really low, even though they're serious crimes and they can involve weapons and assaults and all kinds of things. And then sometimes you run into situations with your case where you have really substantial and serious guidelines, but you don't have a criminal history that it's significant and you have 14 misdemeanors. All right. So, I'll never understand how stumbling out of bed people pick up misdemeanors. I just don't get it. But you only had 2 prior felonies. And I don't want to minimize this case at all because it involves a delivery of drugs. Right. With your co-defendant, and everybody appears to have taken responsibility for it. But I think Swift Insure here is appropriate, just recognizing that you don't have the history or the type of history that often I see as deserving of a substantial prison sentence, though you have the substantial prison sentence guidelines. I wish I had these guidelines for lots of folks that I sentence, and I just don't. So you're going to get this opportunity. I hope you take advantage of it. So recognizing that you have a lot of stints of supervision, either as a misdemeanor or those 2 prior felonies. We'll talk about Swift Insure when you're released from the jail. It's just a different type of supervision. Are you going to be continuing to do it, Mr. Burns?
Yeah.
Okay, Mr. Burns will be the guy doing it. So you couldn't ask for anyone better. He's not there to be, aha, I gotcha. Though he is gonna supervise you in a thorough and strict manner, but you'll hold the keys, so to speak. All right, you either comply with the conditions of the program, successfully complete it, or you don't. If you don't, then you got a lengthy prison sentence that is inevitable simply because of the guidelines. It would just be inevitable. The other thing that you have going for you, Mr. Minima, frankly, is you're 42. So I think Mr. Burns would agree with this. If we do see people that have success in Swift Insure, and those are generally people in Swift Insure that have a substantial criminal history, right? That's why you're there. It's an alternative to prison. This age component seems to maybe impact people's ability to succeed or not. And it's simply this: people get tired of living that lifestyle, right? Incarceration is sort of a revolving door. You do a life sentence either with the misdemeanors 30 or 90 days at a time, with gaps of 6 months or 3 months or a year in between all of those sentences. But it's a lifetime of just constantly in the system and out, in the system and out. Sometimes people at your age, maybe later 40s, I think that's where you're better success, later 40s, but just get tired of that lifestyle.
Yeah,
and frankly, it's not that hard to avoid criminal convictions. It's just not that hard to get up every day and go do something productive and maybe even meaningful, but we'll worry about that later, instead of committing crimes. So we'll give you that opportunity. So for today, though, I am required to impose a $130 crime victims assessment. I am required to impose a $68 state costs. There'll be attorney fees of $400 and court costs of $550. Now I'm going to place you on a period of supervision for 3 years. We're going to impose all standard conditions of supervision, including drug testing and assessment once we get them out for substance abuse, those types of things. You're going to have a curfew of 10 p.m. to 6 a.m. I'm going to require that you maintain employment of at least 30 hours a week, or a combination of that employment and your probation obligations.
Your Honor, can
what else am I missing, Ms. Vanderveen or Mr. Burns?
Electronic monitoring in 10 months.
Yes, we've got to do that. Okay. So I usually save the jail for last, so we'll get to that. I am going to impose, as we talked about, 10 months in the Montcalm County Jail with credit for 164 days that you have previously served. And then once you're released, you'll be placed on an electronic monitoring device for a period of at least 120 days. And then you'll be responsible for the cost of the same. Now, the way that works, while you're being supervised, your supervision fees will be $30 per month, unless you're on an electronic monitoring device. And then in that case, it'll be $60 a month. So it'll be $60 a month at least for that 4 months. Ms. Vanderveen, what else?
That was what I was doing.
Okay. I'm not going to impose a fine when the fine wasn't requested. Mr. Burns, anything else that I missed?
No, Your Honor, thank you.
Okay. So it'll be standard conditions of supervision that Ms. Vanderveen will fill in, and then all the other things that we've talked about here. All right. And then finally, that you have to complete or participate in and complete the Swift Insure program. All right. So Mr. Minima, you do have a right to seek appellate review of this sentence. And if you'd like to do that, you have 21 days from today's date to make that request. If you want a court-appointed attorney to assist you, you have a broader window of 42 to request counsel. So 21 and 42. Deputy, if you could give him that his appellate paperwork at the jail, Ms. Reed's going to help making sure we get it back. Anything else?
Normally they have a form in the jail. With,
yeah, I just asked if they'll
I
provide.
haven't seen him sign anything.
Nope.
There we go.
Okay, anything else?
Nope. That should be
Okay,
it.
that'll complete the matter.
Thank you. Thank you, Your Honor.
Oh my goodness. Good night, Jenny Green. We love you so much. So this toy, it used to have a bell. It no longer has a bell. And by used to, I mean like 4 hours ago when I played with them last. And then yeah, it is now missing a good portion of the bottom of it because they keep tearing off sections little by little. I'm pretty sure I know exactly where my Christmas present from Seattle Jen is going to go. So the other night, y'all heard me like frantically trying to get a message out to Jennifer. And I couldn't remember what her YouTube name was. But I called her out and she emailed me back. Cause I had said, check your email. She emailed me back and she had just assumed that everything was fine because she had purchased the software for me and, sent me the code to activate it and everything like that. But Amazon, when I clicked on the link to download it, it took me to my Amazon. And of course, that wasn't associated with the purchase. So it wouldn't allow me to download it. So it didn't work. And I was so worried she wasn't going to get her money back if she didn't act really quickly. And so I was just trying to get a hold of her to let her know, hey, go get your money back for this. I didn't want it to be wasted and, Amazon just have free money, But she, being the amazing, awesome person that she is, she was watching Replay Crew and heard my message and she got her money back, thank God. And then she turned around and bought an Amazon gift card and sent that to me because that we knew would work. And so I am super, super grateful for that. And I am going to use some of that Amazon gift card to purchase a couple of new cat toys because they need them. So an advance thank you from the kitties. This is like Earl's absolute favorite thing now. And anytime I'm trying to play with Earl, of course, Billy decides he has to take over and kick Earl off the bed. And yeah. So sorry, Iris. Did Iris come in? I didn't see her. Sorry, Iris, what? Yes, the cat did say hi. That Earl's very talkative. And we have those conversations, y'all. You heard Earl and I the other night. Meow. 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 He's too busy playing. Meow. I love when he stands up like that. Oh, that's the cutest thing ever. Sorry. Kitty break. Kitty break. Here. Take just a couple minute kitty break because we can. And because I think the next case is the one that makes me mad. Makes me really mad. If it's the one I'm thinking it is. Kitty break. Kitty, kitty, kitty. Oh, you're going to fall off the edge of the bed. Oh, I paid dog tax earlier. Dog was here. She's laying in front of the heater right now, though. Oh, the camera at that angle. That is a bad angle. Ava, you are being requested. We know you're the real star. Come on. There we go. There we go. There's that face. There's that face. She's super tired, y'all. She's so tired. Well, now it's been paid. Look at Earl trying to play with the toy by himself. She was too. I gave her a treat. Did you miss it? I did it specifically for you. Can't believe Auntie Dolphins missed it. Come on back up. I know you're so tired you can barely hold yourself up. Aw, sweet, sweet Ava. Sweet, sweet Ava. Yes, you are absolutely correct. So you can quit eating my walls. I am going to use Seattle Jen's gift card to get a few cat toys. Their fountain hasn't come yet. Yes, I know. That's why I have to get him new ones. Yeah, he's eating the boa. Yeah, I know that you got that I think it was Archangel, I believe. It was late, so if I'm wrong on that, I'm sorry. But the kitty's the fountain, but it hasn't come yet. But when it gets here, unless it's one of those, but I'm pretty sure both of those, Palmyra Productions said that he got me something that's coming in 3 parts, and I can't open it until the last part comes, because the last part's the biggest part and the main part, and if I open either one of the littler parts, then I'll know what the big part is. So what all that means, I don't know. Palmyra Productions likes doing that kind of stuff, though. Oh, me too. Yes, I thought about that. The problem is my house is not very friendly for random lasers just flying all over the place, and then cats flying all over the place. After my daughter moves out and I get it set up to where it's just me and Billy and maybe Ava, but maybe not, because Ava might be going with my daughter and her boyfriend. She's a little much for me to care for by myself. I don't get a whole lot of help caring for her right now, but doing it 100% by myself is a bit much. But I love her. I absolutely love her to pieces. She's big. I can't clean up her poo, and she needs to go out a lot. And she's expensive, y'all. She not only eats her food, but she literally like breaks through the doggy gate to get at the cat food that it's down the landing. Like you got to go down like 4 steps and then there's a little landing. And then there's a railing against the wall that, there's like this much space. I'd say, I don't know, like maybe 5-6 inches. And I use that spot to feed the cats because, once upon a time, I could put the cat foods there and the dog couldn't get him. Well, then the dog grew and then the dog figured out how to get him. So, and it's the setup, like I can't just put a doggy gate straight across the stairs because the posts don't, like the stairs start before the posts do. So she just shimmies down under the gate when I do that. So, it's okay. I probably will still have her because they're kids and they're in college and it's going to be a long time before they get their own place. They've got 4 years. It's okay. I'm probably going to have her for 4 years. That's plenty time. It's okay. Yes, Eva. But yeah, so she just shimmies under the gate when I put it across. So then I had to get creative. And this gate that I have is like 5 or 6 locking sections of gate. So I started doing like shapes. At first I would like leave 3 of the sections, over folded up, unopened. And then I would open up and I'd make a big triangle. And that didn't work. She figured out that she could move it and get under. And so then I decided to open it up 100% and go around the opening and then come along the wall a bit, or not the railing with it, so that like she would have to like open it up on one end and go all the way through like a tunnel area, to get to the opening of the stairs and then go down. She figured it out. She figured out that she could fat butt plow her way through. She plows her way through everything. So I then started putting a trumpet or a trombone case in front of that tunnel. So you'd have to move the trombone case before you could open up the gate to go down. Well, then she figured out that she could go on the other side. So I'm on my last attempt with this thing. And now I have it extending over the like the railing part, or I have it extending over the stairs part, and then it comes around the stairs opening to the wall and then down, and it has a trombone case. So like if she wants to get through the one side, like she would have to jump down about 4 feet. And that's not Ava. But I think you can But you would want to have a really good internet connection. I'm pretty sure that you can, though. The security. Yeah, she's the breacher of the security. Security breach. But yeah, I can't leave any cat food out because it's gone. She will find a way. But I also can't climb down the stairs, get the 2 plates, and put them back in the fridge every time the cats eat. No, I open a can, I split it between the 2 of them, and then the cats, kind of eat it at their leisure over a couple of hours. But I know when Ava is the one that does it, because the cats leave little wet kitty crumbles of wet food all over the plate and around the plate. Ava doesn't. Ava completely cleans the plate and moves it 3 feet down the shelf thing that it's on. Yeah. Yep. So, and it's really irritating because I know the portion that she's eating is Earl's, because Billy always eats his, most of his right away. Earl will go up, take 3 licks, and then walk away from it for a while, and then come back later. He won't eat it until he's hungry. Billy will just eat all the time. Billy is getting big. He's getting to be a big fat boy. I'm trying to play with him more. I really am. But yeah, Earl, he won't eat unless he's really hungry. And Ava will eat Earl's portion. And so I don't know how much Earl is actually getting of the wet food. But sometimes he gets downright annoying with bugging me to go get him food. And I know, it's okay, I don't know how much you've had though. And when Earl gets fed, so does Billy. So Billy's going to have 6 portions a day if that keeps up. I don't know what to do with these animals. Billy, a chunk. There isn't a place at higher ability. I mean, putting it on the stairs railing it's already 3 feet off the ground. I mean, Ava has to stand on her back legs to get to the shelf that it's on. So it's already as high as it can be without building a shelf on the wall and feeding them on it, and I don't have the engineer capabilities to be doing all those. I'd have to build cascading shelves for Billy to get his big old butt up them. I know I'm having a great time. Oh, I love you. Sleep sweet, my friend, and I'll see you the next time. So the problem with doing that then is, like I said, they get kitty crumbles everywhere, and then I have kitty crumbles falling into my freezer or plates falling on top of my head. I've tried this route. I've tried. And 2 can't fit on top of the fridge. Both cats can't eat at the same time up there. Not without them trying to play King of the Hill. All right, I am going to put another clip on. I'm going to put that clip back on. Oh, that's right. I had to figure out how I put myself up there.
Initial right there. Or no, it's a day. Our next matter for the court is People versus Nicole Christine Trowbridge, is file 23S29942FH. Ms. Trowbridge appears by video from the Montcalm County Jail. Her attorney, Mr. Rasmussen, is present in court. I've had the opportunity to speak with Mr. Rasmussen. My understanding is that Ms. Trowbridge wishes to take advantage of a plea offer. The plea offer is she's going to plead count 3, which is domestic violence, and as a third offense. And there is a sentence agreement in this matter to 17 months with the Department of Corrections. In exchange for that plea, the remaining charges in that file will be dismissed. Further, the people will not follow up with charges for perjury or uttering and publishing this matter.
All accurate?
That is all accurate, Your Honor.
All right, and then Ms. Trowbridge, is that your understanding of the agreement?
Yes.
So raise your right hand, I'll have you sworn. That's your left.
Sorry.
Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put your hand down. The charge in count 3 is domestic violence, third offense. That makes it a 5-year felony and or a $5,000 fine, and a consecutive sentence could be imposed if the assault was committed in a place of confinement. You understand the nature of that charge and the maximum penalty?
Yes.
You understand if you go forward with this plea, you won't have a trial of any kind? Is that what you want to do, is waive your right to have a trial so you can take advantage of the agreement Mr. Rasmussen has worked out on your behalf?
Yes.
Waiving your right to have a trial means you waive all the rights you get with a trial or have with a trial. I have to explain those to you now. It means you're waiving the right to be presumed innocent of all of these charges. It means you're waiving the right to confront any witnesses that would be called against you or to call your own witnesses. It means you're waiving the right to testify at a trial or not to say anything, and the trier of fact couldn't use that against you. It also means you're waiving the right to have the assistance of an attorney at trial. You have Mr. Rasmussen. He can stay with you throughout a trial if you'd like to do that. Are you waiving all those rights that would come along with a trial?
Yes.
2 more things you'll be waiving. The first one is this. You're going to be waiving, by entering a plea, the right to claim at a later date and time that it wasn't your choice to enter the plea this morning. Do you understand that? You're also going to be waiving the right to claim at a later date and time that there were other promises or threats or inducements to you, except those we placed on the record. Do you understand that?
Yes.
All right. Even with this plea, you'll have a form of appellate review available to you. That's called leave to appeal. With that, you can hire an attorney, but if you couldn't afford one, you can request one from the court. Do you understand that?
Yes.
All right. Let's talk about the charge. How do you plead to the charge in count 3 of domestic violence, third offense?
Guilty.
All right. In your own words, what happened to make you guilty of that crime?
To be honest with you, Judge, like my daughter's disability, Natalie is, and I caught her sending inappropriate pictures, and then we got in a scuffle.
Okay, so you say you got in a scuffle. What did you do that would make you guilty of this crime? Did you assault her? Did you batter her?
I pushed her.
All right. So in pushing her, was that meant to harm or embarrass?
I wasn't trying to harm her, to be honest with you. I was trying to calm her down.
Mr. Rasmussen, can you help me out?
She sat on her.
Yeah.
Put her down and sat.
But Ms. Trowbridge, did you push her down and sit on her against her will? That's not something
Yes.
she consented to, right?
Yes.
I think a non-consensual touching satisfies it, right, Your Honor?
Mr. What do you think?
I'm fine with that.
So that's a battery.
I think she committed a battery, and then she continued the battery by holding her down, not necessary. And I don't think that we're making any claim, no claim of parental discipline.
Okay. So Ms. Trowbridge, I believe that I could take a factual basis from the idea that you pushed and then ultimately sat or held against Ms. Lara's will. Well, I guess that's her middle name, right? Natalie Lara.
No, that's her name. Yeah.
Okay. All right. Miss Lara's will. And then both sides are comfortable with that as a factual basis.
I am.
All right. Very good. So back to you, Ms. Trowbridge. Other than what we have spoke about this morning, has anybody else promised you or threatened you or done anything else to you to get you to enter this plea?
No, they haven't.
All right. Other than what we have talked about here this morning, has anyone else said anything to you besides Mr. Rasmussen, said anything to you about what your sentence would be as a result of entering this plea?
No, they haven't.
All right. Mr. Valer, are you aware of any other promises, threats, or inducements?
I'm not.
And Mr. Rasmussen, how about you?
No, Your Honor.
Mr. Valer, do you believe the court's complied with the court with taking this plea?
Yes, Your Honor.
And then Mr. Rasmussen?
Yes, Your Honor.
All right. Ms. Trowbridge, you have any questions about anything that we've covered here today?
No, I haven't.
All right. My last question is, do you want the court to accept your plea to domestic violence, third offense?
Yes.
All right. But I do recognize we did miss something, so let's go back and cover it. Is it accurate that you had a prior conviction on or about April 27th of 2009 for assaulting a pregnant individual, which is violating MCL 750.812?
It's been so long.
Well, did you have that conviction in 2009?
Yes.
Okay. And then did you also have a conviction in 2015?
That could just be of a domestic violence, Your Honor. It doesn't have to be the.
Yeah, it looks like, yeah, a domestic violence conviction in 2015.
Yes.
Okay. So I think that satisfies our third offense notice. And then pursuant to your comments, you wish for the court to accept your plea. I will accept the plea because it has been offered freely, accurately, and voluntarily. Ms. Trowbridge, I'm going to need a pre-sentence report before sentencing. So somebody from probation will be over to speak with you about that. Once that's completed, Mr. Rasmussen will get a copy of it. He'll have a chance to go over it with you a day or so before sentencing, maybe the morning of, just to be so that we can check it for accuracy. Once that report is completed and he's had a chance to go over it with you, we'll get a sentencing date. That'll be about 4 weeks out. Okay, if there's nothing else, that'll complete the matter.
And our next matter for the Court of People versus Robert Paul Mosley is file 23S30678FH. Mr. Mosley was present in court with his attorney, Ms. Reed. We've had a conference at the bench as today is the time and date for sentencing. The recommendations in the pre-sentence report is for swift and sure. The people have had an agreement where there would be a 2-year prison sentence. We wish to withdraw our offer under that matter. We further had a conversation. I would have no objection if the court was inclined to put Mr. Mosley or keep Mr. Mosley on. I guess it's not really my purview. The court has the power to do at that point anything it wants to, but I wouldn't have any objection to it if he enters a plea to home invasion second.
All right. So that's all accurate. I did have a chance to speak with everybody at the bench, and it would be the court's inclination then to keep Mr. Mosley in the current Swift Assured program. That would therefore violate the terms of the agreement Mr. Valet had. And it's my understanding based on his conversation, he would then and the court would grant his right to withdraw from the plea. So then court had indicated that if Mr. Mosley were to enter into a new plea of whatever Mr. Valet offers, the court, regardless of what it is, would keep him in Swift and Sure and wouldn't impose any additional incarceration as a result of this new plea, recognizing that so far, Mr. Burns is here, that things have been going okay in Swift and Sure. And so, Ms. Reed, I assume that you've had a chance to talk to your client about all this.
I have, Your Honor, and he would like to accept that new offer, understanding that his guidelines would substantially increase. Tentatively, we think those are 29 to 114.
So the
months?
new
On
offer
the
was
new
just
one?
because I don't recall that. What's he gonna enter a plea
To home invasion second.
as a
With-
HOA 4?
As a
Very
habitual
good.
four.
Okay. And then, so that's a lot. Mr. Mosley, do you understand all of that?
Yes, sir, I do.
Okay. I could summarize it by saying you might be the luckiest son of a gun that I've seen come through here in a long time.
Yes, sir.
But for the fact that, again, because this was prior to the case, right, that we already put you on supervision for, you'd have a lengthy prison term and it would probably be, not probably, it would be warranted. So, all right, if you're in agreement with all of this, I need you to be sworn and raise your right hand.
You do swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. So home invasion in the second degree is a 15-year felony and or a $3,000 fine. You understand the nature of that charge and the maximum penalty?
Yes, sir.
All right. With the habitual offender that you're entering a plea to, the habitual offender 4, the penalty becomes life. And the court could not impose a maximum penalty less than the maximum term for a first conviction. That's a long way of saying as a result of the HOA 4, that the maximum penalty becomes up to life. And the court couldn't impose a maximum sentence of less than 15, even if it wanted to. So I can do anywhere from 15 up to life. Do you understand that?
Yes, sir.
All right. And knowing all that, you wish to go forward with your plea?
Yes, sir.
All right. You understand that you have a right, if you wanted to have a trial on this charge. You're waiving your right to have a trial.
Yes, sir.
And waiving your right to have a trial means then you will also be waiving all the rights that would come along with the trial. You've heard this before, but I still have to cover it with you. It means you're waiving the right to be presumed innocent of the charge. It means you're waiving the right to confront any witnesses that will be called against you or to call your own witnesses. It means that you are waiving the right to have or to testify at a trial of NHL or not to say anything. Also means you're waiving the right to have the assistance of an attorney at trial. You had Miss Reed. She could continue throughout a trial if you'd rather do that. Are you waiving all those rights that would come along with the trial?
Yes, sir.
Okay. Even with a plea, you're going to have a form of appellate review available to you that's called leave to appeal. With that, you could hire your own attorney. If you couldn't afford one, you could request one from the court. Do you understand that?
Yes, sir.
Okay. You have any questions about anything we've covered so far?
No, sir.
All right, let's talk about the charge. How do you plead to the charge of home invasion in the second degree?
Guilty.
All right, the information says this occurred on or about May 9th of 2022 in the township of Holm, county of Montcalm. Is that the correct date and location?
Yes.
On that date and location, can you tell me what you did at, the information says at 8072 Neff Road that would make you be guilty of that crime?
I picked a crowbar, broke into a house.
All right, so did you have any permission to be in that house?
Absolutely not.
And what was your intent in using a crowbar to enter into that house?
To take stuff.
Take stuff, okay. I do find a factual basis for home invasion in the second degree. Anything else on the facts, Mr. Belay? Ms. Reed?
No, Your Honor.
All right, so Mr. Mosley, is it accurate that on or about March 17th of 97, you were convicted of the offense of breaking and entering a building with intent?
Yes.
Is it accurate that on or about November 12th of 98, you were convicted of the offense of assault with intent to murder?
Yes.
And is it accurate that on or about November 12th of 98, you were convicted of the offense of home invasion in the second degree?
Yes.
All right, I believe that satisfies the HOA 4. Mr. Valet, are you aware of any promises, threats, or inducements that have not been placed on the record?
No.
Ms. Reed, are you aware of any?
No, Your Honor.
All right. Mr. Valet, has the court complied with the court order for taking this plea?
It is.
And Miss Reed, has the court complied?
Yes, Your Honor.
All right. Mr. Mosley, do you have any questions about anything we've covered here?
No, sir.
I just want to make sure, though, we go back. Have there been any other promises, threats, or inducements that we have not talked about?
No, sir.
Besides Ms. Reed, has anybody else said anything to you about what your sentence might be, or I guess in this case, has anybody besides the court or Ms. Reed said anything about what your sentence will be as a result of entering this plea?
No, sir.
All right. You want the court to accept your plea to home invasion in the second degree as a habitual offender 4?
Yes, sir.
All right, I will accept your plea. You did offer it freely, accurately, and voluntarily. I'm going to need you to stop in at probation, and they'll begin the process of completing a quick PSI, Ms. Van. Or do you not need to stop?
I don't need to see him. If Martin or Agent Burns needs to see him, that's
I'll see him when he's done.
Okay, so stop in and see Mr. Burns before you leave. We'll get a PSI completed, I guess, updated with this new charge and our guidelines. And if we have to go out 4 weeks for sentencing, you're already right, and that's fine with me. If we can do it in 2 weeks, that's fine. Whatever works for everybody else. Okay, now complete the matter. Check in with Mr. Burns before you leave.
All right. Thank you, Honor.
You're welcome.
Okay.
Vernon.
Our next matter before the court will be People versus Romario Raymond Vernon. It is file 23S307449FH. Mr. Vernon is present in court along with his attorney, Mrs. Reed. Today is the time and date set for sentencing.
Okay, Ms. Reed, have you had an adequate opportunity to review the pre-sentence report and the sentencing information with your client?
Yes, Your Honor.
Do you have additions, corrections, or deletions?
No, Your Honor.
So you believe we have accurate information on which to base sentencing?
Yes, Your Honor.
Then I'll go over to Mr. Valet. Anything on behalf of the victim?
Judge, I'd ask you to follow the recommendation, including the provisions for jail.
6 months.
Yeah, or at least, I guess, the court, I think some jail is appropriate in this one. Well, obviously, leave it to your discretion to choose the correct amount, but this was a dangerous set of circumstances. Mr. Vernon was pulled over and had a traffic stop. He got acting a little squirrely. The officer said, don't do anything. And he did it anyway. And he took off. I have conjecture as to why. I'm pretty sure he had a juvenile runaway in the car with him, and some other matters. But regardless of what the reason, those are the types where an officer gets run over or somebody else gets taken, injured while he's trying to run away from the scene. I think jail is appropriate under these circumstances. So I'd ask you to give at least some jail or follow the recommendation.
Also the kind of case that the officer gets blamed because they ran a plate, and many folks would just say, well, so what? So what, did he have warrants? Why are you bothering a guy who's just driving to town with warrants?
All right. So did you guys catch that part so far? So far, the officer ran a plate, and it came back that the driver had warrants, or the vehicle owner had warrants. So the officer attempted to pull him over, and the guy ended up, he had a juvenile runaway in the car with him, and he attempted to then flee and put the officer's life in danger by doing so, and put the community in danger by doing so. And let's find out what the argument is from the defense attorney. Makes me so mad. Oh, I'm so mad.
All right, anyway, Ms. Reed, any elocution on behalf of your client?
Your Honor, we're just asking the court to consider a sentence that goes below what's recommended. My client is employed, as he stated in the pre-sentence report. He's genuinely remorseful. Your Honor, I think it is also worth noting, the court already noted, I mean, that he apparently wasn't doing anything wrong when his plate was run by this officer. I also think that there was sort of a cultural aspect to my client's actions. The reason that he ran, he doesn't look like most Montcalm County residents, and being pulled over in a small town by a young blonde-haired officer just made him afraid.
Doesn't that argument and the arguments like that simply,
it doesn't make it right.
Well, of course it doesn't make it right, but the idea, just that it's being floated, continues to put people like your client in danger if they have even the inkling that it's okay to disobey the authority of a police officer and drive away, and then or fight with them, or often he'll say that they weren't respected or anything ridiculous like that, because then it puts these people in these confrontational positions, officer and defendant, which leads to escalation. I have no doubt if your client wasn't doing anything and he pulled over, he probably would have been cited and maybe arrested if he did have outstanding warrants, and that would have been the end of it, and he wouldn't be facing felony charges. So the idea that this is somehow a cultural issue or anything of that nature, I think that's the wrong tactic to take, because it sends the wrong message.
I guess just to respond very briefly, Your Honor, I do believe that my client's feelings of apprehension toward law enforcement officers, or at least this one, were genuine. And I'm sure the court is also aware, we've all been through recent continuing education that helps, that says I'm ineffective if I don't make the argument on his behalf. So
bullshit.
I don't know. There's anything I've heard that says you'd be ineffective for failing to make that argument.
And I don't see anything in here that indicates that he indicated any fear of where it was. I think that is a complete red herring, and it doesn't do service to what's occurred. I would have been much more impressed if you said it was a cultural thing because he's from New York. I went to buy that theory that he ran because he's from New York. Maybe that's what they do there. I have no idea. But it's bothersome to me that that's what we're down to on where the officer didn't do anything incorrect, and we're down to saying, well, geez, I was scared. It's an offensive position to me.
And it's not consistent with what your client said. He said that he was just making a delivery, attempting to make extra money. So,
Your Honor, my client he would like to speak for himself as well.
Sure. Go ahead, Mr. Vernon, go ahead.
Well, I know I did what was wrong. Well, I did what was wrong at the time. I wasn't thinking at the time that happened. And I'm really sorry for this first time I ever did that, because I stopped. After I pulled off, right? I stopped right around the corner. And then I got out the car, stopped and watched him drive in. Because I didn't hide or nothing. I was just right in plain sight. But I don't know if he saw me, but my car was in plain sight. And then when he picked me up from Kentwood that time, he told me that he didn't really chase me after the fact that I stopped. I told him everything in the cop car when he picked me up from Kent County. And I'm sorry for this. Everything I never had any problems in New York when I lived there. I'm Jamaican. I never had any issues in New York with a bicycle ticket. Once I got to Michigan, all my problems started. Since I was 25 years old, then my problems started. I never had any issues, but I'm always alone. I don't stay away from people. I don't like to be around people, but every time I choose the wrong person to be, my ex-girlfriend, she just liked to lie. When she was in prison for 2 years, and then she used to lie on me and say a lot of stuff on me. So for this relationship I'm in now is way better for me, and I'm doing better as it is. But that was a mistake that this had happened, and I'm sincerely sorry for this issue.
All right, Ms. Reed, did you have anything else?
During the whole time he spoke there, he didn't once say, Your Honor, I was in fear of my life from that officer, and I was raised that cops are bad and I should be fearful of them or anything like that. Her whole argument.
Yes, Your Honor, just to follow up on our earlier discussion, I'm going to stand by the argument that I'm making on my client's behalf. I believe that if he were a white guy and he were driving through Carson City, he wouldn't have got pulled over. I do believe that discrimination was a factor. That does not absolve my client of responsibility, but I'm going to stand by that. So I'd ask
You
the court
believe that
to.
if a white guy was driving through town and the officer ran the plate as he did here and the registered owner had warrants, the officer would have said, nah, I'm not gonna go look at that. I'm just gonna let it continue to drive through town.
Your Honor.
Just let her finish. I want to hear her explanation. You really think that's
I don't think he would
misreading?
have run the plate, potentially.
You don't think he would have run the plate? What else do they have to do there? We're not a metropolitan area, right? So I would assume that's what all the officers are doing. You don't think so?
Your Honor, I think
One more time. What that happened first time?
She and people with her mentality are the reason why racism is what it is. She's making it worse. And before people go off on me in the comment section about how I don't know anything because I'm a well-off white person, blah, 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 blah. Bullshit. And I would just like to say that this person right here, this is Papa Henry. This man, he's stepfather of an ex of mine. Papa is now passed. But he and I were very, very, very close. And a lot of people already know this, but the last guy that I dated that stayed with me for over a year, the one that I always referred to as Backpack, yeah, he wasn't white. Oh, no, he was not. It makes me so mad because you want to know how we get rid of racism? We stop referring to people as that black guy, that Mexican guy, the Asian guy, or the white guy. Stop it. Unless you are giving a description of a person to EMS or police or fire department or for some emergency, and their race has to be mentioned, that's the only time that it should be mentioned. And constantly playing the card is what causes division. And he's not the one doing it. She is. She needs her license revoked. She is a terrible defense attorney. If the only way that you can see to defend your clients is to use their race as the method of defense, rather than the merits of the case, rather than the truths, if the only thing that you can do to defend your clients is to claim racism, you are a shitty attorney.
May I speak, Your Honor?
Sure, go ahead, Mr. Vernon.
Okay, so as I was going to make my delivery at the time it happened, right? So I was he was at the gas station or whatever he was at, because I did see the cop. I was driving regular speed limit and everything. And then I was about to deliver my products. Then he pulled not behind me. He went the other way around. Because I saw him pull out, but he didn't went I was passing this way. He went the other way to go around the area. So I basically, I don't know if he was following me or he probably referred my plate already, right? But he probably went the other way because I was making my delivery. I was doing roadie at the time. So I don't know if he was
Let me just stop right here because maybe I forgot in the, did he have warrants at the time?
I didn't know.
I don't believe that he had.
But he did, correct?
I believe he did.
Yeah, so
I think
are you or Ms. Reed or any one of you disputing that the officer shouldn't have pulled over the car if he's got information that the car is registered and has warrants? Should he just ignore that? That's what I don't understand the argument.
Your Honor,
Should he?
that's certainly not what we're saying, and I think we've kind of gotten aside,
That's kind of what you are saying.
aside from.
You are saying, you're saying that if he had been white, the officer would have just let go.
Your Honor.
And your client's saying that he went around the block, he was kind of watching him, probably already ran his plate, but so what if he did? He had warrants. Did you guys, do you recognize that a warrant, the language of a warrant says that the officer is commanded by the court to take that person into custody? It doesn't say that the officer can ignore it. It doesn't say the officer can decide to do it next week. It's a command to take that person into custody.
Yes, I agree with that as well, Your Honor. And so to, I guess, just wrap this up, I'm going to stand by the arguments that I've made on my client's behalf. I understand the court disagrees with my arguments. I'd ask that you don't consider those against him, seeing that you clearly disagree. Ask you to treat him fairly here today. He's taken responsibility. He's at the mercy of the court.
All right. And Mr. Brennan, only because I want to circle back, is there anything else that you want to say before the court imposes sentence?
Yes, sir.
Go ahead.
I'm sorry for what I have done, again, and just asking for the best so I could change my life back to normal, the way because I'm currently working. I've been there for 5 years now, so I'm sorry. I'm just trying to get this out of the way so I can start my life again. Like, just pay whatever I need to pay now, all of my fines off and everything. It's just because I know if I do get jail time, it might slow. Like, when I do get out and fines and stuff, it might mess, like, it'll be hard for me, just saying. And my mom is moving already.
He's allocating better than she does. You know what I think? Give her degree to him. I'm for it.
So it's gonna be not have a place to, I'm trying to move with her also to Texas. So I'm sorry for this.
All right, so Mr. Vernon, here's what the court's going to do. I'm going to adopt these recommendations. I'm going to do so for several reasons. First, you stand before the court with 3 prior misdemeanors. It is interesting because your criminal history looks like you have, frankly, more than that. We've got 6 entries here, the last one being the current case. But we've got this disturbing the peace in Ottawa County. We've got this, which started as an assault, by the way, because I was making note of that. But you end up pleading to disturbing the peace. And then you have this larceny, which is apparently pending in Kent, but we didn't even talk about that. Nobody's talked about it. Do you know anything else about the status of it? Just that it's pending. Right. So we've got to take care of that. You got this domestic violence that was dismissed in 2020. You got this breaking and entering, which was in 2020, and that resulted in, I don't know what it resulted in because it simply says a disposition and a sentence date of 2021, and it doesn't even tell us what it was for. So I assume that's part of where we have some issues with our criminal history. And then again, it starts off in 20 with a DV. And then on top of all of that, according to the narrative, this plate, which came back to you as registered owner, had warrants at the time. And that makes sense when I look at maybe pending cases and all this other stuff. So you kind of have made a bet that unfortunately you have to lie in when you encounter a police officer if you've got warrants out there. And then you have made a bet that you kind of have to lie in when you come before court and you have 3 prior criminal histories. Now, having read this narrative, I concur with what's been stated here this morning by the people. Mr. Brennan, I don't buy that you were just out for a delivery that day. If you were, there'd be no reason to run from the police, to fight with the police. Worst case, you just would have been taken into custody on the warrants. And frankly, when I reviewed the PSI, I don't even know that there was a traffic citation to cite you for that day. From the narrative, you would have had these warrants. The case would have been done. You just would have had to deal with whatever the warrants were. The point is, you wouldn't have a case here at all. And in spite of what Ms. Reed has argued, in spite of what you think, if you had done that, if something else wasn't going on, in other words, there'd be no Montcalm County case. And it would, the officer, if that's truly what you believe, the officer would have been hard pressed to come up with some sort of, I guess, trumped up traffic ticket or citation or arrest, considering that I think all of them out there today have body cameras. Everybody has a cell phone. That's just not what's happening here. And I just reject that argument. So all of this is, in essence, you're doing, and you have to be responsible for it. So I don't know what was going on that day, but they are not, no, we're done, sir. I'm going to tell you what I'm going to send you to. I've given you every opportunity to explain your side and say anything you want. I just don't buy it, sir. I don't think that the actions that you had that day were the actions of somebody that was not engaged in something else that they did not want the police to discover. That's just how it looks. And 1 + 1 here adds up to 2. So I'm going to adopt these recommendations. That means, sir, I'm going to place you on a period of supervision for 2 years. While you're being supervised, your supervision fees will be $30 per month. You can't engage in any criminal activity. So that means you can't violate any criminal law of any unit of government while you're being on supervision. I am going to require that you maintain employment of at least 30 hours a week, or a combination of employment and your supervision obligation. You will have a curfew of 10 p.m. to 6 a.m. So you'll have to be in your approved residence between those hours unless you first have permission from your field agent to be outside your approved residence during those hours. Sir, I'm required by statute to impose state costs. In this case, you have 2 felonies. So the state costs will be $136, and that's broken down as $68 on each count. There'll be a $60 DNA testing fee. There'll be attorney fees in the amount of $400, a fine of $500, court costs of $550. While you're being supervised, the supervision fees will be $30 per month. They'll also, required by statute, be a crime victim rights assessment in the amount of $130. While you're being supervised, your supervision will also require random drug and alcohol screening. And then finally, sir, I am going to follow this recommendation for the incarceration because I do believe that it's appropriate, it's consistent with your history of a criminal history and the facts and circumstances of this case being 2 felonies of fleeing and eluding, and then also resisting and obstructing a police officer. I will sentence you to 6 months in the Montcalm County Jail. You do receive credit for 3 days that you have previously served. Now, Mr. Vernon, you do have a right to seek appellate review of the sentence, and if you'd like to do that, you have 21 days from today's date to make that request. If you want a court-appointed attorney to assist you, you have a broader window of 42 days. All right, so Ms. Reed, if you want to approach and have him acknowledge his appellate paperwork, we'll lay it has. I'm going to place that in the file. Ms. Reed, Mr. Blay, anything else?
No, thank you, Judge.
All right, Mr. Vernon, you're all set. Good luck to you.
This is the case of.
Yes, absolutely. Racism does exist. 100%. It absolutely does. But it is not the end all be all for every situation. And it should not be used as often as it is. I have seen many occasions where it was used in situations just because the person wasn't getting their way. And that just turns my stomach. You know, I've seen people who have done nothing but good for people of all races who have been called racist, and it's so uncalled for. You know, just because someone wasn't getting their way at the time. It's horrible. And why would you want to go through life living like that anyways? That's such a hateful way to be. Like, rather than think that everybody loves you, you want to go through life thinking everyone's against you? No. No, there's something wrong with that logic. Because more people are about love and acceptance and partnership than there are who aren't. I fully believe that. I 100%. Yes, racism absolutely exists, but it does not exist on the scale and on the level that it is perpetuated, that the media has led people to believe. And that is 100%. It is the media and it is some of the government. Yep. Oh, yeah. Oh, yeah, yeah. Yep. That's why I won't tolerate it on this channel. I had the other night, someone came in and said something that immediately banned. I've only banned 2 people from my channel. That person was the first. I will not repeat what they said. But it was so wrong. But that is the only thing that's going to get somebody an instant ban. Nope. I won't even, at that point, like, I won't even try to reason with them. Nope. I don't want them here. She's not going to change their mind. Telling them that's unacceptable, don't talk like that, blah, 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 blah. That's not going to change their mind. And it would take far too long for me to be able to have any impact on them. And in the meantime, I just don't want their hate. I don't want it here. Yeah, it was. Yeah, apparently they didn't see who the judge was. Dumbass. All right, I think there's only 1 or 2 left, and then I will go to sleep, I promise.
People State of Michigan versus Jim Ed Brown, 98S, 164. This is a motion to discontinue being on the sex offender registry.
All right, then Mr. Brown, what do you want to state in support of your motion?
Been on the registry for 25 years. I've abided by a lot of different rules. I would just like to be able to move forward in my life and be able to have other doors open to me for employment, for housing, for a better future for myself and my family.
Oh, this guy. This guy thinks he's fooling someone.
Hang on 1 second. Did you file this on your own? It looks like Mr. Van Ack.
He filed one back in
2013?
2012, I believe, sir.
I'm not seeing yours today. Hold on.
Should be the very last.
Yeah, it was in 2012. It was late summer,
We're getting there.
early fall.
Get there. There you go.
Got it. All right. So that you just did this on your own. Okay. Okay. And then Ms. Kraus, what's the position of the people here? In essence, his argument is this was before 2011.
I would object, Judge, and so as I, again, tried to glean through the old stuff, because we would not have a file on this anymore, what we were able to put together, you know, there was I'll call it a disagreement among the parties between the victim and the defendant in terms of whether this was forced versus consensual. He was granted YTA initially, but lost that status shortly. He was sentenced on December 10th of 1999 and lost his YTA status on August 9th of 2002. So 3 years later, he lost his YTA status. Since then, just looking at his criminal history, and he has in 2001, he had a domestic violence charge conviction. In 2007, a SORA student safety zone violation. In 2014, he had 2 counts of R&O and a DV second and was sent to prison. In 2019, a false report of a misdemeanor, and then in 2020, disorderly obscene conduct.
He does not like having his record read aloud like that. He is fuming.
I don't see anything that would say he should get off the sex offender registry. If anything, this is a case where I definitely would want him to stay on. It would, you know, again, the victim, there was conflicting accounts, I guess, of what happened, but the victim said it was not consensual.
Mr. Brown, anything else, sir?
Sure. My Home Use Training Act was not, in fact, taken away in August. I was in alternative directions from June through October of that year. And the only reason why I left alternative directions without the program being complete is the night before I came back to alternative directions, I blew a dirty breathalyzer. And with that being done there, I asked my mom and dad to contact my probation officer because I knew I didn't blow dirty. I even said this in my sentencing way back in 98 or 99. Yeah, 99. I told the judge, I said, I didn't blow dirty. I know I didn't, but my probation officer would not allow for my parents to come pick me up from the halfway house and bring me to go do a blood alcohol content test. She denied such a conversation had taken place, Your Honor. I went on to serve 45 days in jail, and the judge never signed on successfully discharged from probation, and my YTH, to my knowledge, was never revoked.
I was looking for that.
I mean, if it had been, I had never seen the documentation, Your Honor.
So I have that in the file right here, sir. Signed by Judge Hoare on August 13th of 2002. Says this is a discharge from probation, sentenced on 12/10/99 to 45 days in the Montgomery County Jail for violation of probation. Credit to be given for 30 days previously served. His probation under the terms of the Home Youthful Training Act is revoked, and he is unsuccessfully discharged.
Your Honor, may I approach so I can see this?
Sure. It's right there. You can read it. You see, do we have anybody online? Because somehow the whole computer shut off and I noticed. The cord under the below was not on, so I click it back on. I don't know how things went on.
This was signed August 2008.
Right here, it was signed at the bottom by Judge Hort, right here.
2002.
Yep, looks like 02. Let me see.
My probation terms, Your Honor.
02. I'm sorry.
My probation terms was 30 days and 1 year in jail.
It's like August 13th, actually, of 02.
I don't follow how Judge Hort was not on the bench at that time, and it was another judge that I was sentenced under, how he can go and date or sign such an order 3 years after I've been off from probation.
Well, this is when you were discharged, August 13th of 02.
No, I was not. That's something completely different. I was discharged from probation in 99, Your Honor, for the CSC. And there is no conflicting stories as far as whether there was coercion or force with Brandy Halleck. I don't know where that comes from, but she was a willing participant to have sex.
So, Mr. Brown, I don't know where you're coming up with this idea that you were discharged in 99.
I was sentenced to 1 year probation and 30 days in jail.
We weren't sentenced until December of 99, so how could you be discharged?
No, I was sentenced to 98 because I was 17 years old. Yes, ma'am.
So here's what I have in the file. So you have your notice of appellate rights. Those were signed on December 9th of 99. And then on December 10th of 99, there is, this is interesting, December 10th of 99, there is a petition and order for discharge from probation. That was signed by Judge Hort, sentenced on this date to 45 days in the Montcalm County Jail for violation of probation. Credit to be given for 30 days previously served, unsuccessfully discharged.
What I can see on my system is November 12th of 98 was the sentencing.
Yes.
The original sentencing.
That could be, now I'm seeing a 10/16/98 date on the PSI.
Yeah.
But still, that doesn't mean he wasn't still on probation, because.
No, I was discharged.
And then he was discharged in August of 2002, unsuccessful from probation.
Right.
So it was extended.
No,
it was also
An extension, but.
the YTA Act was taken away.
That's inaccurate. I didn't do.
That's what the court file says.
I understand, but I don't know how the court file would say that because I was off probation in 99. I was sentenced back down here in the other courthouse.
But your CC, okay, the other problem, YTA must have been taken away because the criminal sexual conduct charge shows up on your criminal history. It wouldn't show up on your criminal history if YTA hadn't been taken away.
Right.
So it shows up. So I don't know.
Yeah. So, Mr. Brown, here's what I'm going to do as it relates to your petition today. I'm not comfortable, based on what we're discussing here today, to grant the petition. To the contrary, based on the supervision that was not completed successfully, whether the YTA was taken away or not, but it certainly seems that way from the file. There's paperwork that clearly says that. And then here's the other thing that works against you, unfortunately. You've got a long history of convictions after the one that you're seeking to be removed from the registry here. And frankly, the other thing, I'm not even certain the court has the authority to grant this request, absent something right on point. And when we looked at this, I don't know that there is anything on point. The other thing is, I am certain that victims are allowed to give input, and I don't know that I've heard, were you able to reach the victim on this?
I'm not sure
Yeah. Okay. So there's a whole host of reasons why the court's not comfortable granting your petition. A whole lot of reasons why, some of that I've already cited on the record, that would make sense that the court would not do that. So today I'm not going to do that. Now, if you want to do some research and you can find some clear authority that allows the court to do that, and then more importantly, some clear authority that also doesn't direct the court to post-conviction activity, I would be interested in that, but I'm just not aware of anything that is along those lines. So for today, respectfully, I'm going to deny your request. Okay, what do we have next?
Yes, my whole channel, my chat, my Discord, everybody, I have the best people on earth. And I can say that. I can say that I have best people from all around the world because I really do have people from all around the world. Got Australia, New Zealand, Canada, of course, the United States. Let's see, Belgium, England, just a few, just to name a few. And yes, I am getting very sleepy. It would be time to get back to being silly, but you're gonna have to be silly in the Discord because I'm gonna go to bed. I'm gonna fall flat on my computer desk if I don't. I'm sorry. I love you guys all. I tell everybody that about myself. Nobody believes me. Not here anyways. All right. I love you. And I hope you all have a wonderful night. Be safe, be well, sleep sweet, and I'll see you tonight. Much love.